Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. Sorry, I started the stream and then just forgot to start the rest of it. I forgot to hit the intro. I'm like, oh, this show's going to start eventually.
It sounds like one of my shows, Nick.
How's it go? Welcome to my very special guest, the much maligned, the often misinterpreted, and the hilariously based Andrew Branca.
Hello, everybody. Hello. By the way, I do, before we jump into things, there is one thing I want to mention. A couple of weeks ago, you were kind enough to have me on your show to talk about Nat Lawyer Chick and me being labeled a con artist and such. And we did a bit of debunking of her. And as part of that, we made a 50% off offer to everyone to become a Law of Self-Defense Platinum membership. And in the process of all that, within 24 hours, Natalie had made me enough money to pay for my new BMW and two Rolex watches, not just once, but every year in perpetuity. And none of that would have been possible without you, Nick.
Oh, thank you.
And in appreciation, I have a modest gift for you. I just need to know where to spend it, brother. I set you up, man. Of course.
This motherfucker texts me. He says, "Hey, I've got someone I need to buy a nice bottle of whiskey for. What would you get?" And I'm like, "Well, this is the one. This is the one." Aw, thanks.
There you go. Yeah, so I just need to know where to send it. I was hoping to get it to you in time for our show next Wednesday. So I wasn't sure if your P.O. box, which I already know, was the best address for that or what. But just DM me whatever the best mailing address is, and we'll get it out to you.
Yeah, I'm sending it right now.
And for anybody who still has a special opportunity just today, I'm extending that Natalie Lawyer Chick 50% off, become a Law of Self-Defense Platinum member today during this show at lawofselfdefense.com/Nick. Maybe she can buy me another Rolex watch. I do have my eye on another one. That'll be awfully nice and much appreciated. Natalie, you are the best.
That's fantastic. The internet is the weirdest place of magic and dreams and memes. But well, I'm happy to have you on the show. We are here to watch New Mexico versus Dean. I'm Cummings, and this is an extreme skier, apparently, because that's a thing. I guess who he shot a man, and he is alleging self-defense. Is that? I have not been following this case at all, but you've caught up to the whole thing, right? Like you're fully in.
Yes, so I've watched every minute of it. I did start a day late, so last week I was playing catching up a few hours over the course of the week. By Friday afternoon, I was all caught up. Saturday, I should say. By Saturday, I was all caught up. That was most of the trial. The state rested on Friday afternoon, and the defense only had one day of testimony, case in chief. They had 5 witnesses, the first witness of which was the defendant himself, which was very exciting. In fact, there's some remarkable, straight out of the gate, number one, defense witness. And the guy has a reputation for having mental health issues. So I was assuming he was not going to take the stand because, I mean, I don't know if any of that's true. That's just what was reported in the media. And apparently one of the reasons this trial was delayed 2.5 years while this poor bastard sat in jail all that time was because there were competency concerns in hearings and so forth. But they put him up. He did a great job on the stand. He was fine. It was the state that lost its fucking mind doing cross-examination of this guy. I don't know if you have a clip of that video. I have a clip that I actually optimized the audio on. If you want to watch a couple minutes of the state's cross-examination, let me see if I can remember how to share this from my end. Let's see. Oh my God, I'm so terrible at this stuff. Let's see.
There's a present button down at the bottom.
Yeah, I've got that. I have too many tabs open is the problem.
Oh yeah. Is it a link or do you have it? Oh,
I got it.
You got it?
Yeah, I got it on there it is. All right, so this is a point in the cross-examination where Ms. Blueberry here is just flailing and the most obnoxious Karen you could ever imagine. None of these women in the court have a hairbrush, apparently. Dean Cummings is on the stand. He's being very straightforward, very direct, doesn't appear to be obfuscating at all. And she decides that she wants to have him replicate in court, like a skit, reenact the fight.
I heard about this.
And the victim in this case, where she's going to play the role of the giant blueberry victim. She's about 7 feet tall, it looks like. And she's going to actually hand him the actual rifle in court, ask him to work the bolt. Nobody checks to see if this thing is loaded, points it at her.
Baldwin is the bailiff, apparently.
And perhaps the most shocking, and when he cycles the bolt, there's a little zip tie through the ejection port, like, so you can't do that. Well, he cycles the bolt, the zip tie breaks and falls right out of the gun. So for all we know, there's a round chambered. And they're doing this reenactment, and she's ridiculously acting like she's raining blows down on him, and he's falling on the ground backwards. And finally, the defense counsel goes, Your Honor, this is scaring the fuck out of me. Can we do something else here? And they had a blue gun, a blue rifle, an inert plastic rifle there the entire time they could have used for this purpose. But she had them use the real rifle. But here's a 5 minutes or so of this, if you'd care to watch it. Ready?
Yes, sir.
I would like you to sit down, with the court's permission, and show me how you're holding the gun.
The audio was terrible in the original. This is better.
Mr. Ariola, when you were able to chamber around this weapon.
He doesn't want to do it. He's looking at defense counsel.
Let me see what my attorneys think.
Yeah.
I'll allow it.
The judge is like, okay with me.
Now,
wait, I get to point a gun at you? Sweet.
You grabbed the weapon, it was against the table or the wall. Okay, grab it just like the time you grab. No. Hold on. You weren't down like that when the argument started, were you? I'm talking about the very beginning. He said, get that. Okay? And he knocked you down how? Well, knock me down. But pretend like you're going to get me down.
Knock me down.
Yeah, this is like impossible to hear. I mean, it's fine, but
yeah. Is it not worth it?
Quality. No, I want. We're good.
He came in and he had something in his right hand. I didn't know what it was. He just slammed me. I got knocked into a countertop here.
Right after the point where he points to the rifle at her, that's the fun part.
Like this, and he's coming at me. He's swinging with his right hand.
Why would you ever let the defendant frame the encounter as a state prosecutor? This is the dumbest thing they can do.
I bury him back, and hits me again, I fall down again, and the door jam of the bathroom. I've got this like this, I'm down again for the second time, so I'm down.
And all this time, he's coming at you.
Yeah, whole
He's
time.
coming at you, like this.
Whole time I'm walking in.
Yeah. And when did you
So then he
chamber
grabbed
the
the gun.
round? How did you chamber the round?
I didn't do that yet.
Okay.
You can see this
He grabbed
in the
gun,
rifle.
Where did you grab it?
Right there on the barrel.
Right here. Grab the barrel. Yeah.
And I'm scrambling. He's swinging, he's got his other hand.
With his other hand.
Thanks for just making the case.
Oh, and what's he doing with this hand?
He's swinging that canister.
Okay.
So I'm blocking everything.
Did you fill the canister?
I finally got back to him
Excuse me, did you fill the canister?
a couple times.
Was it heavy?
I don't know. I never picked it up.
Guys, I can't wait to explain to you just how fucking stupid this prosecutor is for doing this.
I just grabbed his jacket right here and that way he pulled it on.
Okay.
And what?
And then when did you chamber it? How did you chamber
Okay,
it?
so then I got the gun out of his hand. He's out of the bathroom entrance. I pulled this
He's
back.
still coming at you?
No, he stood back.
Oh, you stood back a second.
I'm gonna do this.
Look at that. Oh, there goes.
Stop. Okay, I need to be right. I'm not moving back all the way to the bedroom.
Officer, hold on. Double check that firearm. Hold on. Double check that firearm.
That's it. That's really it.
The bailiff's like, let me actually check that gun. You just could have chambered something in that. Oh my gosh. Okay, so here's the issues we've got, guys. The same
state, by the way, where the Alec Baldwin shooting happened. I mean, within miles of the Alec Baldwin shooting.
If you don't know, okay, so here's how cross-examination works in court. On direct examination, that's where you call your witness. You have to ask open-ended questions. you let the witness tell the narrative. So the person calling them doesn't get to coach them through the testimony. Cross-examination, you actually get to and should really only ask leading questions. You should develop the narrative that you want to tell, and then through questioning, have them admit to that narrative on the record. That's on the record, like Daryl Brooks would say. That's how you want to do a cross-examination. This state attorney just kept asking him, and then what happened? What happened next? Well, where were you then? So he gets to craft the entire narrative versus the dead guy who will never get to say that didn't happen. This guy will never be in court to say, actually, I stepped back away from him. I never grabbed his gun. He's like, yeah, actually grab the gun right here. He's like, it would be helpful if you had a knife and also 8 friends around you. And he said, I'm going to kill you, white boy, or whatever. Like that would have been, this basically what just happened is he got to frame the entire narrative of the encounter, and the state asked him to, like idiots. If the defense had done that on direct, the state probably would have objected. Oh, that's beautiful. Thank you for sharing that. Yep.
I got police sirens going out my window. Hold on.
No worries. While
I thought it was such a great idea to get an office downtown. What a mistake. I got trains going by, fire engines going by. It's just ridiculous. Thank God I only signed a 2-year lease. Jesus. what a mistake. I mean, the restaurants are nearby. That's nice, but urban settings, forget it. Yeah, so the whole trial so far, the state's done nothing from opening statement onward to present anything that's a compelling argument counter to self-defense in a trial where they have to disprove self-defense beyond a reasonable doubt. The defense witnesses were the defendant himself, who came across, to my mind, as completely credible, certainly didn't say anything that undercut his claim of self-defense. Several people from the community who'd been victims of the victim, who'd been attacked, maced, subject to hammer attacks by the victim, had a reputation for being drunk and violent and using drugs. And then they had their use of force expert come in who said, yeah, all the trajectory evidence and everything recovered at the scene, completely consistent with self-defense. And so wait, the cross of the state by the defense brought in a use of force expert.
Right. No, but I'm before that, you said that there were other people who had been attacked by this guy. So they were able to get prior acts evidence and character for violence evidence in through known reputation in the community.
Yep. Right.
Okay. So real quick, guys, you again, on the legal explanation side of this, character evidence is generally.
And by the way, Nick, I should tell you, one of the reasons one of the reasons I'm sure they had the defendant testify first is because he testified that he had knowledge of these events, that the defendant himself, the victim himself had recounted these events to him. That made it relevant to his subjective state of mind, not just character or reputation evidence. And so that's what opens the door to allowing this corroborating evidence in.
Okay, so typically you don't get to bring in evidence of someone's character or a negative character trait unless it's used to rebut a positive character assertion. And you typically don't get to bring in prior acts evidence. So you wouldn't normally be able to parade a bunch of people and be like, yeah, this guy hit me with a hammer or a bottle, or he punched me in the face like that, because it's highly prejudicial and unrelated to the present act, unless you can find a way to do it. In this case, he's got a present sense impression, the defendant himself, because this guy tells him, yeah, I beat the hell out of people for fun or whatever. So he's got that. And then the other thing is you could bring in character evidence if it's a known reputation within a given community that is relevant to the case. And so if this guy's got a character for being violent, now the defendant's thoughts about, oh man, I've heard about this guy, become relevant. So that it's not looking good for the state on this one. Why would they prosecute this?
It's unbelievable. And then when the state cross-examines, by the way, the defense use of force expert works for the Department of Public Safety in the adjoining state in Arizona. So he's normally a prosecution witness called here by the defense. And when he was subject to cross-examination by the state, virtually every question the state asked him was, well, isn't it possible that this, or isn't it possible that it was completely a defense line of questioning intended to raise reasonable doubt in a case where the state has to disprove self-defense beyond any reasonable doubt. Everything was, well, is it possible? Is it possible the defendant was standing on the top of a bunk bed that had no mattress on it and fired the shots from there? I mean, it was completely insane.
Yeah, if you're the state and you're developing the is it possible narrative, your case in theory should just be dismissed. If it's on any element of the crime and it's is it possible? No. The answer is that's not good enough. But the state should have a rock solid narrative that eliminates those possibilities, that eliminates that reasonable doubt. And if they don't have it, the person should walk. So,
and in theory, there could be such evidence, right? In theory, the victim might have been shot in the back from a distance, or I mean, there could be facts that would be inconsistent with self-defense. They just don't exist here. And this poor bastard's been in jail for 2.5 years since this event occurred, and they have there's no case here. There's no way on the legal merits this can be a guilty verdict. But I also hear that the victim was known, liked. It's a small community. Everybody knows everybody. He's lived there forever. The guy who shot him was just moving into the community, trying to buy land from the victim. So he's a relative stranger. The victim is Hispanic. The shooter is white. So there may well be political dynamics here that drove the prosecutor to bring a case that has so little legal merit.
And that's a critical. That's a critical thing about something that we've talked about on a couple of these self-defense, alleged self-defense cases, some of them being legitimate, some of them not being so legitimate. But whether or not you're justified in pulling a trigger is merely one small step on the equation of the justice, or in the justice equation. And there's a whole bunch of stuff that can screw you over that has nothing to do with whether or not you're guilty or innocent. Look at Kyle Rittenhouse. That entire trial, based on the facts presented in the criminal complaint, should have been dismissed immediately. But you've got a district attorney who is exceedingly liberal following a racially charged police shooting and riots that ensued afterwards. And then you have you have someone who could be passed off as white, fighting against someone, and it can be framed in a racial narrative, despite the fact that the people you shot were not quite black, just a little shade lighter than black. But that political calculus was more a factor in the trial of Kyle Rittenhouse than any of the facts were. And it didn't matter that he was obviously not guilty. What mattered is he had to spend a bunch of time being maligned by the media as a racist murderer. He always will be remembered as a racist murderer by a certain group of the population. That's how it's going to be. This guy, you're saying he spent 2.5 years in prison?
No bail.
Or in jail, I guess.
In jail, right, local jail, yep.
Which many prisoners would tell you they'd rather be in prison than county. Frankly.
Yeah, well, for one thing, it's less chaotic because you have a relatively stable population. People develop their relationships. You know, you kind of know what to expect. Jail, it's different psychopaths every week.
Right. And the people who are running through jail can be really bad dudes who just haven't been convicted of anything yet. And so yeah, it's just imagine 2.5 years of your life snuffed out by some cockhole of a prosecutor is just pissed off at you at something else and gets to use you for their political ends.
I presume you have the court feed standing by, Nick?
Yep. It's
okay,
we're just under 9 minutes away from it getting started.
Yeah, so it's been one of those interesting cases. I didn't even have it on my radar. Law with Mike. Do you know Law with Mike? Another
Law Talk with Mike. I've heard of it.
Law Talk with Mike. Yeah. So he invited me on his show to talk about it, and I hadn't heard of it. By the time I saw his invitation, it was too late for me to come on. But then I was aware of the show, so I was catching up a day late throughout the course of last week. But it's another one of those cases where it's unbelievable how little merit there is to charge this. He was charged with murder 6 days after the event, and they got a grand jury indictment when they were still waiting for forensics results that never came, that were never actually requested. That was another thing. The lead investigator on this case, when they called him to testify, the state called him, as they had to. He's the lead investigator. He couldn't remember if he had testified before the grand jury for the indictment, because after the grand jury, and he had testified, but after the grand jury, something happened to him. He was in a coma for 9 days, and he lost all memory of the investigation.
Oh.
So he literally knows nothing about what happened. He couldn't remember if he testified in front of the grand jury. They had to show him his transcript.
Seems, that's That's an issue, I guess.
And when they showed him the transcript, it was the defense showed it to illustrate that he had told the grand jury things like, well, we're anticipating that the trajectory analysis will be consistent with a murder here. And of course, the grand jury returns an indictment for murder. No one ever requested trajectory analysis. So not only was it ever going to confirm or corroborate murder, it was never going to happen. It had never been asked for.
God, it's insane.
And that's one of the grounds on which the grand jury was asked to return an indictment for murder, which of course is why the state's privileged to keep this guy in jail for 2.5 years without bail.
To the Rumble audience, to the Odyssey audience, I want to say a couple things real quick. Hi guys. I love you all. You're fantastic. You're terrific. Thank you for joining us here. We see we're at 9,200 and growing, just like my pants. And it's really fantastic to have you. But I got to tell you guys, if you're just watching on Rumble or Odyssey, you're missing a little bit. You're missing just a little bit. If you were on rekietalaw.locals.com, you could have been treated to 4 hours of live streaming already today.
Wow.
I've already done a 4-hour live stream this morning, and the Locals chat has been on fire since yesterday. Fantastic community we've got there. Really the best people making all sorts of horrific memes.
And what's that URL again, Nick?
rekietalaw.locals.com, the only place you should be watching anything on the internet, even if it's not me, because you should be in my locals talking about what other people are doing as well. It's the best way to enjoy the internet. There is no way around it. And guys, I can tell you with confidence, it is the best $5 a month you'll ever spend. No one has ever regretted it. And if they did, it's because they suck. So anyway,
I love that headline. Slept from 8 p.m. to 2 a.m. and now I can't sleep. Yeah, I was up at 3 a.m. this morning. I don't know why, but my wife wasn't very happy about it. I mean, she wasn't too angry, but she wasn't.
I was on a show yesterday. I do a Dungeons and Dragons live stream with geeks and gamers on every Monday, which is super nerdy, but it's fun. And it starts at 7. By 8 o'clock, I messaged them. I'm like, guys, I'm dying. I don't know what it is. I cannot stay awake. I need to go. So I left and I hit my bed and was just out. But then 2 o'clock, Lady Raggets woke me up because she woke up and she's like, hey, what the hell? And I was like, oh God. But then I was like, well, I'm awake now. I just slept 6 hours. I haven't slept 6 hours in like 3 months. So it's like, I'll just get up then. And it was a blast. It was a blast. But guys, I've got the greatest sponsor of the show soon. It's coming. I'm so freaking excited for it. So we'll be talking about that soon as well, but it's not official yet. So, but we'll get there. But anyway, make sure you check out rekietalaw.locals.com. That is my personal grift. I'll do it again later, but honestly, it's a good place. We had a lot of fun in chat yesterday, and have had a good day so far today.
You still shopping for sponsors?
I'm always shopping for sponsors.
All right. Well, we should talk about that.
I will gladly do so.
Law Self-Defense did its first ever sponsored thing this year. We've never done that before, but it looks like it's going to pay off. So now we're more interested in that kind of thing.
Well, yeah, I'll gladly talk about that. Here, I'll pull this up. We're just waiting for the live coverage to start. A big shout out, by the way, to my favorite legal network, Law and Crime, for providing this constantly solid quality courtroom analysis. Well, not analysis, observation, I should say, while leaving the door open to much more entertaining and educated professionals to come in and provide the legal analysis that they so sorely lack.
So yesterday, for the first time, I figured out how to do polls in the live chat on YouTube. I didn't know how to do that. So the state had rested, so I did a poll, and then they they did direct and cross of the defendant. So I did a poll, and then the defense rested. I did a poll. Every poll I did, it was like 95 to 98% not guilty. 2% thought they were guilty. Then someone sent me the same type of poll from Law and Crime, and it's like 45 to 45. Like, those dumbasses. What the hell are they telling their audience that half their audience thinks this guy could be guilty on the legal merits?
Well, they're not telling him anything. That's the thing. They just leave it. And look, everybody should be able to watch something and not be swayed by an opinion or whatever. But if you have a modicum of education on these topics, a lot of this is not a surprise. No. Not a surprise. Like when one of my favorite trials that we've covered was Curtis Reeves down in Florida. Yep. And this is the movie theater popcorn shooter. And going into that trial based on the narrative and what I had seen about it at first, I was kind of like leaning like this might be a bad shooting, not really sure. But as we start walking through things and as the evidence is actually presented and you get away from the media narrative and into the factual narrative of the case, you start to go, yeah, this guy's not guilty at all. And I remember we had similar polling issues where here on the show, it was something like 90%, 85% plus for not guilty. And then you go over to Law and Crime and it's much closer to 50-50. And like, that's cute and all, but the 50-50 on some of this 50-50 when your life is on the line is really critically important.
Yeah. And unfortunately, a typical jury is more represented by the Law and Crime type of audience than it would be by our audience, unfortunately.
The good news is for all of you guys that you're not on the jury, and being educated on the facts and on the law can allow you to have informed discussions or just informed, self-service sessions about any particular case we're watching. So I love doing these damn trials. I really do.
Man, I was on I almost did a Rekieta length stream yesterday, nine and a half hours.
Damn.
Yeah.
Oh, and I should say, and you're invited to this if you're interested at all and had time. It'll be later tonight, or not late tonight, but it's going to start after we're done here. I will be doing election coverage here on Rumble, same channel, but a new stream. We will be doing I'll be doing election coverage here. I'll be inviting people to pop in and out as they choose. And if you want hard-hitting, professional election analysis, go somewhere else. We're going to be telling jokes and drinking and having a fucking blast, laughing at the potential of a red wave and the sad whining and weeping that could produce. I frankly don't care what happens. I mean, I have my preferences, don't get me wrong, but I learned in 2020 that what you want to happen in an election, and maybe even what happens in an election, might not matter so much. That just might not be a thing that actually factors into reality at the end of the day. And we get to just have a fun time talking about this. I'll be stream sniping the Young Turks because they're going to have Matt Gaetz on. So that should be ludicrously stupid. And we're just going to have a good time today. So
here's a funny thing. A few people have asked me to come on, and I always say no because I can only do these late night things like once every couple of weeks. I'm old, folks. But guess what? I got an email from Steve Gosney today. Apparently his flight got redirected to Denver. So he's arriving in Denver late tonight. He's going to end up crashing at my house. And awesome. So I got to pick him up like 11 o'clock at night anyway. So as long as I'm going to be up, maybe I will pop on.
Yeah, absolutely. Tell him I said hi, of course. I bet because they've got they got another hurricane headed towards Florida right now.
He was in Arizona on some kind of like weekend vacation, and yeah, maybe that's what happened. I don't know, but I've had an email from him this morning. It's like I canceled. He's coming into Denver. He wants to know if he can crash. So of course he can. We got a guest room and a hot tub and all that jazz. He's going to do his criminal law course from Law Self-Defense headquarters tomorrow, instead of from Florida where he would normally do it. So yep, that'll be great.
Awesome. I love that guy. I want to hang out with him. Sounds cool. Let's see. What do we got here? So we've got the court feed up. Have you done an analysis of this judge's chair?
No, the judge has been good, though. I have to say, the judge has been very straightforward. No one's tried to pull it, except for the stupid rifle nonsense. when the state lost their mind on cross of the defendant. The judges pretty much kept things under control. No one's tried to go too far out of bounds. He did dismiss 2 of the charges once the state rested. So there were 4 charges. There's murder, the lesser included of voluntary manslaughter. Then there was 2 ridiculous charges, tampering with evidence and concealment of identity. The concealment of identity is premised on the fact that although the defendant called 911 and identified himself immediately after the shooting, he was later being questioned by a police officer and only gave his first name.
Oh, man.
Witnesses?
That's,
Yes, Your Honor, we propose-
there you go, I guess.
Excuse me, 2 rebuttal witnesses
Oh, rebuttal. I was afraid of this.
to talk about, put in context, not in detail, but the fact that these incidents that the neighborhoods testified about was an ongoing neighbor dispute. He called on them as much as they called on him. And oh, I'm sorry. And the other thing was that when you responded to these calls, did you get both sides? Were there differing accounts of what happened? Yeah.
Put it up here.
So first of all, there's a bunch of hearsay that can't come in there. So she wants to call a police officer who didn't get called to every incident.
This defense counsel talking right now is excellent. I would hire her.
So we can't talk about all of the incidents that we have police reports for. The court didn't allow us to have our witnesses talk about the ongoing neighbor dispute. So if the court doesn't allow us
did defense rest yesterday?
Out of our witnesses,
Yes, but now the state's asking to be able to call rebuttal
Griffin to say
to the neighbors who testified about the character for violence.
back and forth. Sometimes Mr. Ariola called. Sometimes the neighbors called. If the state gets to do that,
It was so damaging.
They can talk about how
The
they were
state.
shot at, how their elderly relatives were called a cunt.
Because
You want to get into it? Let's get into it.
You want to get into it? Let's go. Let's go.
Are we on the record yet?
No.
Who's
So-
the,
So,
how's this judge in this case?
judge is very good,
Your
very,
Honor,
very straight,
as I recall, you
in control of his courtroom. I like the judge.
pretty well. And on cross, Miss Walker
The woman on the left is a defense attorney, one of 2 defense counsel, Carrie Morrison. She's excellent.
They denied it. They acted like it was all Mr. Gurriel.
I'm not going to allow Officer Griffin to testify on that. It was my ruling was very limited. It was limited only to show that defendant had mace and used the hammer. That was it. And that's
Not
all.
the victim, he means.
So in terms of
The judge sounds like he's drunk all the time, but his actual decisions are very good.
She wants to call
Masks should not be
Tomlinson,
allowed in a courtroom.
who went
Yeah,
to
this is New Mexico right now.
First time on October 28th, 2022. 2.5 years after the incident, took photographs of the scene, which were just provided to us a couple days ago. Even though the pictures were taken on the 28th, I don't think we got them until the 3rd or the 4th. So that's new evidence that shouldn't come in because it was provided after trials started.
Typical state shenanigans here.
And
Rings
then
of
you
finger.
ask him questions about when you submit items to the lab for testing, how do you decide what to send? That testimony is already in evidence. He's already testified to when he sends things to the lab, what happens. Quite frankly, his testimony is wrong, and his testimony is going to be wrong when he takes the witness stand again.
Ms. Romo.
This is the lead investigator who was in the coma. He doesn't
sorry?
remember
We're not on the
anything.
record.
Okay.
Okay,
You-
all right. So-
Judge, first of all, yes, Frank Tomlinson, Sergeant Griffin, and myself and co-counsel went to the scene in response to their demonstration and their expert's testimony, which was provided late, for the specific
so
purpose
crazy.
of seeing if what he was saying made sense in the parameters, giving everything, the room and whatnot. So as
Whatnot.
I think it was Ms. Moss who pointed out so
Technical term of
eloquently
art.
last week, we don't have an obligation to provide demonstrative rebuttal evidence, and that's all this is going to be, is demonstrative.
Your Honor, there are photographs taken 2.5 years later of Tomlinson standing in the room like this, trying to demonstrate the size of the room, and you can't even see where this hand is. They didn't even take the pictures right. Not to mention the fact that they're photographing a scene that's 2.5 years old.
Your Honor.
Hang on. They want to have him show a picture of the mirror that was hanging on the wall. We don't know how that was changed over the last 2.5 years. I'm sorry their lead detective didn't go to the scene for 2.5 years. It doesn't come in. This is ridiculous. He can't show a picture and talk about a mirror.
I'm going to try to interview her after the trial.
On October 28th, 2022.
There's other things he can talk about, Judge. For example, and I know I asked at least 2 witnesses about that drywall. That drywall, I think one of the experts said, well, it could be.
Look how weak the state sounds here.
And the point of that is to rebut the testimony that there was a struggle in this little room, and also to rebut the inference that was made yesterday in front of the jury by Ms. Moss that we just made this up, I guess. No, we measured it. It's accurate. And it's relevant to whether there is a struggle in the room. You can push on that drywall, even a little bit, it bends. It's very thin. The likelihood of a struggle taking place in there.
Yeah, but Ms. Romo, what I'm saying is this is more collateral than rebuttal.
How? I don't understand what do you mean collateral?
You're just adding more. You're not rebutting what they say. You're just adding more to what your side brought forth.
That's exactly
I don't
right.
even know, for example, I don't even know, for example, if that heater now is back on the wall.
It is. The heater's back
Is it back?
on the
Is
wall.
it back on the wall?
We're not going to show it back on the wall, Judge.
The heater's back on the wall.
And,
Hold on.
And moreover, the point is the pictures that are in evidence, they can see those pictures and the items that are still there, as in the pictures that were taken in 2020.
But that's not the question. The question is, my question, for example, that heater, is it still in the very same position it was the day of the, no, now it's
back
hung
on the
up.
wall.
I'm not showing that heater. I'm
It's-
not rebutting that.
Of-
And I'm
of-
also,
of-
another thing I'm going to rebut, Your Honor, with Mr. Tomlinson or
She
Sergeant
sounds so
Ricketts.
frantic.
The
She knows she's
defendant got
screwed.
out there and said that bathroom is not right across the front door. It clearly is.
And she's already shown a photograph
It's-
to
no,
demonstrate
no.
that. Yes, you have a picture in
It's already been,
evidence.
that's been established already.
Yes.
I'm not gonna, this is all collateral and it's changed so much. And I'm
He
using
means
the example of the
cumulative,
heater
but-
in that
He means cumulative.
if it's changed since then, what else has changed since then?
When there's a break, Nick.
Also, in rebuttal to their experts saying that all crime labs can do certain kinds of testing, which is not true. Our crime lab does not do, for example, they don't do residue testing. They don't do chemical testing.
Well, who knows that? Does Mr. Tomlinson know that?
Yeah.
Your Honor, he didn't testify that all crime labs can do everything. He actually testified that the mace, in order to test something for mace, would have to be sent to an outside lab. That's what he testified to.
Correct.
Well, Judge,
Now, the state's got themselves in a difficult spot because the
I love
ballistics
arguments not
investigation
on
in
the
this
record.
case was pitiful.
Because you
Right.
have to be just
Yeah,
brutal.
I'm not going to allow any of that as truly rebuttal. It's collateral. It's out. The photos are
Judge,
recent.
can we not make an allowance for the fact that they gave it to us at the last freaking minute? We went out the same day they gave us their demonstrative evidence to test it. And he's going to
He's not
testify.
qualified to test anything.
He's going to testify about his observations,
When?
and that testimony will be used an argument.
Hold on.
Observations 2.5 years later.
When? He wasn't there until what, recently?
October 28th.
But Judge, some things are not going to change. And the
How do we know?
cause and plot that John made up,
The state had the opportunity to address all of this with their actual witnesses
and that's important.
in their case in
What's
chief.
important
None of this is necessary for
That
rebuttal.
room was so small.
So
The
what's going
dimensions
on?
of the room were known
Here's the
and
problem.
knowable the whole trial.
What we're trying to do is, this man was out there on October
Okay, I already made
28th.
I'm not going to allow it's shown right there how small that room is.
He
We
was
don't need any
out
more
there
of
on the
that.
28th.
So you get
They
a
could have
rebuttal
asked him when he
phase
was on
in
the
a
witness
trial?
stand, and they didn't.
Unless there's
Because
no
it
reason
you
to
know
call
there
a
wouldn't have
rebuttal
been, there would
witness.
have been an
You
objection
can't just
because
Hold on.
because
Stand
excuse me
testimony.
because it is rebuttal evidence,
So
the
this is
rebuttal
critical for the
demonstrative
state
evidence, which you
to
will
win
know
here.
and they will know.
Otherwise, they
I
go to
cannot
closing
present
arguments.
until
Yep.
it's raised by defense.
Everyone talked about the size of the
Strictly for
room.
rebuttal. And they
Absolutely
argued
not.
so eloquently at their motion hearing that they do not have to provide demonstrative evidence,
But we did.
but we did too.
Okay.
And they're saying we didn't go up to the 28th. Well, they didn't get to do the second interview till the
Well,
28th.
But this isn't rebuttal. That's still the baseline problem here, is that this is not rebuttal. And there's no reason at all.
I'm not gonna lie. The other thing, Ms. Romo, did you look at that step down instruction?
Yes, I did.
And did you send it to Mr. Morrissey?
I didn't get anything sent from Ms. Roma that I'm aware of.
We did.
The judge is changing the subject.
Oh, yes, of course. I have their jury instructions from 2 weeks ago. I thought you were talking about
Are you
something
comfortable
recent.
with that step down instruction? It sort of follows.
Well,
The
let's go
step
through
down is
it.
the mitigation for murder
I'll
to
let you guys go
voluntary
through it and they
manslaughter.
give you the instruction.
Modification.
Exactly, Judge.
I read the step down instruction this morning and I don't have any concerns about it.
Okay, the one we're saying. Well, I'm gonna put down the I'm gonna get the instructions together. I'm gonna give you.
Really
I'm
not
gonna number
concerned
and
about
get
it
you
because she's
copies,
probably sure
and then
they've
I wanna
nailed the
go over
fucking
them
acquittal.
on the record, and then we will read them to the jury and go to closing
Oh, yeah, I
argument.
feel like I'm back on Farron's channel.
Oh, nice.
A bunch of women yelling at me.
Okay, so what just happened there, chat? In case you missed it, the state just lost their rebuttal phase. Like the state does not get to present rebuttal witnesses because their rebuttal witnesses were cumulative. They were not going to be there to rebut or refute something that came up during the defense's case in chief. So if they're just going to rehash the same evidence and the same testimony and the same facts as before, it's not going to be helpful.
Right.
Usually,
Rebuttal is for when some issues came up in the defense case in chief that the state would have had no reason to expect, so they get an opportunity to rebut those new issues. None of these issues were new. All of them were talked about before, or they're irrelevant. So, yeah, good call by the judge. The judge has been good throughout this trial, I have to say.
yeah, I mean, it's nice to see something like that. So a lot of times if you're calling a rebuttal witness, you're bringing in another witness that wasn't really critical to the case unless you kind of foresee some of the possible issues from other witnesses coming from the other side. And so you've got, okay, we might need this person to come in. Or maybe you have another expert who's going to come in to go after something that's brought up that your expert wasn't covering. Or maybe a door got kicked open during the defense's case in chief that wasn't available for the state's witness. So you're like, oh, okay, we couldn't bring this witness in. They were excluded in limine. However, we've now got an opening to go in. And that's why you've got this.
And we saw this during the George Floyd trial, right? Because the defense brought an expert who testified about a number of issues, a technical, scientific, medical expert. And he raised a new issue that hadn't been raised before, and that was the carbon monoxide from the car, the exhaust that was near George Floyd. That had not been covered apparently in his report that had been shared in discovery with the state, and the state got to call back one of their witnesses as a rebuttal witness to talk about this carbon monoxide issue. But that's how it happens often with experts. An expert will have disclosed to the state, a defense expert will have disclosed to the state, I'm going to talk about A, B, and C. And then in his actual testimony, he also talks about D. Well, the state wasn't prepared for D. It wasn't in the report that was shared in the discovery, so they get to have a rebuttal witness on D. Next, so this defense attorney, Carrie Morrissey, both the defense, all the lawyers are women here. Both the defense attorneys are solid. Carrie Morrissey's great. She's a real pit bull. In fact, I went to look up her contact information because I'm thinking about trying to interview her after the trial. And when I found her law practice, they had a Martindale Hubbell review of her, and it was like 3.6 out of 5 stars. And I was like, what the hell is that? That's not the lawyer I'm seeing in court. So I went and looked at the reviews. One of the reviews is just 5 out of 5. Just from another sole practitioner, no comment, just 5 out of 5 stars. The second review is by a judge, 2 out of 6 stars. You got to read this review. I shared it on the screen here.
Okay, so this is
the review that's supposed to be 2 out of 6 stars. Attorney tends to be unnecessarily hostile. This is from a judge. Oppositional and borderline on courtroom decorum and respect for the court. She zealously advocates for her clients and generally demonstrates above average trial skills. Folks, that's a 10 out of 5 stars for a criminal defense attorney.
Yes. Yeah, you want that. That's put that on the resume, slap it on your fridge.
I've already heard I have to like laser cut and a big brass plate and hung in the office with a giant pair of testicles under it.
Oh my gosh.
Well,
I
what you
did,
saw just there from the defense attorney, that's what she's like. She's been like pretty much the whole trial. Very, very aggressive, very pitbull, very, very disagreeable, which is exactly what you want for a criminal defense attorney when you're staring down the twin barrels of a murder conviction. Hey, Jeff.
Speaking of very, very disagreeable, we've got Legal Vices. What's up, buddy?
Oh, not much. I'm just depressed. There was 100% less hair pulling and eye scratching than I was hoping for during that little go around.
Jeff's like, install a mud pit before they start arguing.
The bailiff, get the baby oil.
Some Jello.
Here we go. Jason of TGA with a Rumble rant says, rebuttal sounds like something they should call an expert testimony from Dollhouse Phil for. Oh, I agree. That would be great. That'd be good. Legal Vices says, I hope this prosecutor makes the defense counsel so mad that she just calls her a cunt. Yay for Rumble censorship. Okay, and I have heard some rumors about Rumble censorship in the chat. I'm going to be asking them about that because I'm not sure if that's like I have no idea what's behind that, but I'm going to try and get to the bottom of it. But what I can tell you is where there isn't censorship is in the locals chat, rekietalaw.locals.com. You can catch you next Tuesday all the way to Thursday. I guess. But how you going, Jeff? You were covering some other trial earlier, right?
Yeah, a brand new Florida trial that started yesterday. Some guy stabbed his wife to death penalty case.
Dang.
Yeah.
Did he do it? Was it worth it?
Well, apparently the defense testimony was slightly worse than the Chandler Halderson defense opening statement. It was basically just listen to everybody and listen to the evidence and make your own decision.
Gonna need you to keep an open mind on this one, jury.
She literally, it's like she read the transcript from Halderson and went, "Hey, this just might work the second time around." Keep an open mind, listen to the witnesses, make your own decisions, that kind of thing.
That's not good.
Standing in a pool of blood, so you know.
Yeah. Yeah, you really want your defense opening statement to, like, you technically don't need to, but you would like it to construct a narrative of why either what you did was justified or why you didn't do the thing you did. Because, like, maybe you were, I don't know, in Afghanistan and not there. Like, that would be helpful to have. Like, if you're not there, your defense attorney is not gonna say, look, I need you to keep an open mind about this and just consider all the facts. They're gonna say, homeboy wasn't there. Very simple. Wasn't there, couldn't have done it. You want that narrative thing going on.
They didn't really have much of a chance for a luxury. I mean, in a nutshell, jealous husband sees what he thinks is his wife dancing with another man in a bar. Turns out she was actually dancing with one of her girlfriends for about 5 seconds. She goes home. It ends up with her locking herself in her bedroom, climbing out a window, him going and catching her, doing the stabby thing, and then he stabs himself in the neck, tries to commit suicide. Not a lot to work with there for the defense, but hey, just keep an open mind, listen to the testimony, and they're listen to the first responders, listen to what they say, make up your own mind.
Ooh.
Yeah.
Not good. Not
Politics
good.
are at play in this, though. It's definitely a political death penalty case.
Did you talk to Steve about it, or is it in his district? Is he, do you know?
Oh, I just kind of found out about it and jumped on last minute. Didn't think it's in the
if it's not in his district, he might be able to provide some, share some insight. If it's in his district, he can't talk about it. He's involved in the
county that starts with a K.
I can't remember what county he's in, to tell you the truth.
I can't either. And I talked to him about it recently. That's one of those details.
He's up in the Daytona Beach area, whatever county that is.
Real quick, just a quick plug to the people on Rumble. Specifically, we've got 12,270 people watching, which is awesome. I haven't been covering this trial, so thank you guys for showing up. I hope some of you got my notification on YouTube that I'm live over here. And if you've not watched on Rumble before, make sure you smash that subscribe button here on Rumble and get used to coming back here, because I'm going to keep you coming. But the most important thing I need people to do is go ahead and click that plus button down. If you're on a browser, it's right below the video on the left side, pound that plusy. That is the effective like. That would be on YouTube or another service. That's the Rumble like. If you're on mobile, it's actually above the video on the right. There's like a thumbs up, but it looks kind of like a boxing glove because I guess they can't draw. But make sure you hit that thing. And here's why, because on Rumble, this is an actual meritocracy, and those likes drive the video up the recommendation list. There's a literal leaderboard. It's like if your video has, X amount of likes, it goes on a leaderboard every day. There's a top 50. And I love dominating the hell out of that leaderboard and making it call me Big Daddy Rackets. So please go ahead and click that plus button. Let's get more people to the show. Let's let them know where they can watch the best trial coverage on the internet. That's right here.
Hey, Nick, now that we got more people here, you mind if I mention your gift again?
Absolutely. We're just waiting for the judge.
Yeah. So a couple weeks ago, Nick was nice enough to have me on his show so I could debunk Nat Lawyer Chick, the Natalie Lawyer on Twitter, who had blocked me and then called me a con artist for my professional practices. So we did that, I don't know, for an hour or two. We had a good time. And at the time, I had offered as part of that show a 50% off Law Self-Defense Platinum memberships. Well, we sold enough of those platinum memberships to pay for my new BMW and two Rolex watches. Thanks to Natalie, and as a modest token of appreciation to Nick for making that possible, I got him a little bottle of this stuff, which I heard from a reliable source was Nick's favorite. In fact, I heard that from Nick because I asked him and tricked him into telling me what his favorite was. So, Nick, this will be in the mail to you, hopefully today. So you'll have it in time for our show next Wednesday. I'm so excited. I'm so excited for that. But I am really also very excited for our show next Wednesday. That is the 16th. That is a late night Branca no tie stream. We'll see. We might bring we might have some other guests. We're just gonna have some fun, talk about some stuff. And again, if you come to watch the trials, you got to check out the nighttime show. Basically every weeknight, 11 p.m. Central. And we sometimes cover very serious topics. We sometimes cover non-serious topics that are a lot of fun. And every Friday we have kind of just a chilled out stream that has that's kind of designed to deprocess from all the serious bullshit you have to deal with during your week and get you ready for the weekend. So make sure you come check those out. What mobile interface am I looking at for the like button? Definitely not above. Oh, they might have changed it. Let me look at my device. But in the meanwhile, again, while we wait for this judge, Jeff, what have you been covering other than this trial? What are you up to lately?
We did some amazing 1900s Shackleton expedition yesterday on our Maritime Monday, where we tied in some whiskey to an old Antarctic expedition. We got O.J. Simpson coming up on Thursday. Watch F. Lee Bailey work his magic on racist cop Mark Furman.
There you go. Mark, I like how Dana Carvey called him Mark the Fuhrman.
And then we're going to watch my very, very favorite part of the trial once we get done with that in a few weeks, is watching Barry Scheck dismantle Dennis Fung, the LA criminologist, on an 8.5-day cross-examination that ended with the prosecution's own criminologist getting off the stand, shaking the hands and hugging the defense lawyers.
That's terrible.
They just made him their bitch.
So Nick, I saw somebody in the comments asking how I turned Natalie into a BMW and two Rolexes. That's how, folks. That's how in one day, that's the bump in our memberships, our platinum level memberships, the highest level ones, thanks to Natalie's criticism and our debunking on it. When that happens in one day, that's annual recurring revenue right there. Thanks, good. Natalie. You're the best.
Oh my God. Oh, I want to go start a feud with somebody now.
So wait,
I wish it happened every week. It's great.
So Jeff, are you? You say you're going through the O.J. Simpson trial effectively, or at least testimony from. Are you going through all of it? Are you summarizing it? What are you doing?
I'm just doing the main parts that I think are really, really fascinating, that show I mean, it's 27 years ago. It's not going to change anybody's mind whether he's guilty or innocent. I just want to play some of the highlights of the defense cross-examination and direct testimony to show how fantastic lawyers and fantastically powerful expert witnesses can create reasonable doubt in the mind of a juror. So we're going to be doing the F. Lee Bailey, Mark Furman thing. We're going to be doing the Dennis Fung, Barry Scheck thing. His name just skipped my the Chinese American blood specialist guy that's on everywhere.
Did you just suggest that reasonable minds could differ about O.J. Simpson's guilt?
Yeah, apparently.
Not guilty. The man didn't do it, and the murderer is still at large
on a golf course in Florida somewhere.
and fact, that's does anyone know where does anyone know where Gosney was 27 years ago?
Right. And that's the important thing is it's not guilty is not innocent. And that's what I tell people. I'm not trying to change your mind. I'm not saying he's innocent. I'm just saying the state, if they're going to take away someone's life, is they're trying to do in this ridiculous situation, put someone in jail for the rest of their life, they have a burden to meet, and you cannot let them off the hook because someday some innocent guy is going to be in this situation.
Right. Exactly. Like O.J. Simpson was. O.J. Simpson, much maligned as the murderer of Nicole Brown Simpson and, quote, that other guy. When he clearly did not do it, and reasonable doubt won the day. And the reasonable doubt had nothing to do with how just terrible the state's prosecution of him was, and had everything to do with how the facts were on his side from the start. And the evidence had no indication of guilt. And also, of course, having like one of the most ridiculously good defense teams ever compiled.
And you just don't get better than F. Lee Bailey. I mean,
it gave the world, what's that guy's name? Cato Kalin?
Cato Kalin, yeah.
We would never have known about him, but for that trial.
It's and like, Barry wasn't Scheck, that around? Yeah. That wasn't quite the same year, but it was close, wasn't it? When we had the Dream Team hit the Olympic basketball, when it was like,
that's why they were calling them the Dream Team too. The OJ's Dream Team. Yeah.
God, it was like, and just the Dream Team. That was so unfair.
That was from the last half of my 2L year to the end of the first half of my 3L year was when it was on TV. I missed so much law school and went through so many videotapes with that, but it was fun to go back and watch the opening statements and just see just how disjointed the prosecution was in their opening statements.
You didn't need to watch the defense opening statement if you watched Theodore Edgecombe's opening statement, because he just literally stole Johnny Cochran's opening statement word for word, just with 1/1000th the charisma and talent. B. Ivory. I need to get B. Ivory on the show.
Oh man. Brooks, I still wanted Brooks to just bring him in as counsel. That would have been awesome.
I have some big lawyer guests to get on the show that I've been speaking to. Alan Dershowitz.
Oh wow.
Is interested in talking. Mark Randazza, who I have tremendous respect for, is interested, and I've got possibly I'm trying to think of his name, Norm Pattis, the guy who just represented Alex Jones up in Connecticut, and despite the outcome, really did a pretty commendable job managing the courtroom in the way he did in a very unwinnable case, with a very unique kind of client situation. And he did it very well. He executed the profession to the top level, I would say. So those are people I'm looking to have on the show sometime very soon. I've spoken to, I haven't spoken to Mr. Pattis yet, but I've got his contact information specifically in regards to the show. I didn't just creep him in a phone book or whatever. So I'll be reaching out to him very, very soon.
And creep the other ones on the phone. Actual law before we start up, or maybe we're too later. So what's the state have to do? The state has to disprove self-defense beyond a reasonable doubt. The self-defense claim has up to 5 elements: innocence, imminence, proportionality, avoidance, and reasonableness. Avoidance is off the table. New Mexico's a stand your ground state, wouldn't be applicable for other reasons. So there's 4 elements. If the state can disprove any one of them beyond a reasonable doubt, they win. They've disproven self-defense. What they have to do is either disprove beyond a reasonable doubt, or they would have to prove beyond a reasonable doubt that the defendant was the initial aggressor. I don't see it. That the defendant used deadly force disproportionately to the attack. I don't see it. That the defendant was not defending against an attack actually occurring. No evidence contrary to that. And the defendant's perceptions, decisions, or actions were somehow not reasonable under the circumstances as the evidence shows them to be. And I don't see that happening either. Not even close to disproving any of those 4 elements beyond a reasonable doubt. But when we listen to the state's closing, that's what we're listening for. Which of those 4 elements, innocence, imminence, proportionality, reasonableness, can they disprove beyond a reasonable doubt? That's their threshold, their burden. And if they can't do that, it's an acquittal.
What I saw just from the testimony you showed earlier, where they had the defendant doing a demonstrable of the encounter in the dumbest way possible. I saw the defendant testify that he was knocked down
3 times.
That he got back up, that he was knocked down again. He retrieved a gun at some point, that the assailant, the victim, whatever, grabbed the barrel of the gun, attempted to get it from him, was also repeatedly striking him. Did he have anything else? Was there a knife or something, or was that just her awkward way of holding her hand?
No, he had a pepper spray canister like this one here in his hand. Now, the defendant says he didn't know what it was in the hand. He just knew he was being struck with some object. And he had heard from the victim himself, that the victim had previously attacked people with a hammer. So as far as he was concerned, he was, he had reason to believe he was being struck in the head with something hard enough, dangerous enough to be a deadly force attack. That's why he went to the gun in the first place. Of course, once the 2 men are fighting over the gun, then it's just a gunfight at that point. Whoever gets the gun lives.
Well, because we've talked about this. There can be mutual self-defense claims. Both of them can be valid. That's kind of how it works. We talked about this in the context of the Ahmaud Arbery case, because there was I think actually the first show that you did with me was talking about that case long before it actually went to trial. And we had talked about the fact that the shooters in Ahmaud Arbery could have perceived him as a deadly force threat for advancing on them and reaching for a gun, whereas Ahmaud Arbery could have been justified in advancing and reaching for the gun because he perceived a deadly force threat in them pulling out or brandishing or something like that. Now, we didn't have all the facts at the time, but that was a discussion that we had back and forth about some hypothetical scenarios. So in this case, once there's a gun, potentially being pointed at someone, you're now in a position where either person could manifest an imminent fear of serious death or bodily harm sufficient to sustain a justifiable shooting. Pretty wild how that can turn out. So based on what you've watched, though, Andrew, which avenue do you think the state is most likely to go after? Do they have any case? Like, I know you said you didn't see it, but where do you think their strongest argument lies?
It seems they're going to try to go after either it's a complete fabrication, which they don't actually have any evidence of, or proportionality. At worst, it was a mace attack. Mace is typically non-deadly force when it's used in a defensive context. And if you characterize the mace as non-deadly force and you make that the worst attack by the victim, then going to a gun would not have been a proportional response. But the state's arguments are very confused. Like initially they had a tampering with evidence charge because the defendant had washed his face and changed his clothes, saying they had chemicals on him that were burning his skin. His skin was burning. The state and they charged him for tampering with evidence for doing that. They're simultaneously saying there was no mace attack. So which is it? I mean, was the guy not maced and therefore there was no attack, or was he? But in that case, there can't be a tampering charge because there would have been no mace evidence for him to tamper with. or was he maced? And if mace is being used offensively, I would suggest it's a different attack than if it's being used defensively. Defensively, it's reasonable to infer that the attack will stop once the victim of the mace has been neutralized as a threat. But used offensively, it's an ongoing, continuous attack. It's typically used in bank robberies. When a cop is maced by a suspect, the cop's going to go to his gun every single time. Same as we see these cases where the cop's taser is taken from him by a suspect, and the shooting of that suspect is unlawful because the cop could be disabled by the taser or by OC or whatever at any moment. So these items used defensively, non-deadly force. Used offensively, it's quite different because you would have a reasonable expectation the attack would continue.
Right. Yeah. Because if I come at you and tase you, the expectation is that what comes after the tasing is not good. Like, to quote.
In any case, the defendant is saying, I didn't even know what it was in his hand. I knew after the fact that there was some burning on my skin. So I'm inferring that the mace was released in the room. But at the time I was being struck, all I knew was he had an object in his hand, repeatedly striking at my head with it.
Yeah. And to quote one of my favorite self-defense experts, Bas Rutten, former UFC fighter Bas Rutten, but more importantly, former bouncer, do not let them knock you out. Because what happens after you get knocked out, you don't know. That ongoing attack is a different thing. He talked about playing hide the pepper sauce bottle. You definitely don't want to wake up to that ring of fire. Not a good plan.
And the state offered no narrative for why this would have had, no motive on the part of the defendant, why he would have wanted to kill this guy. There's lots of forensics evidence consistent with the defendant being not consistent with the defendant's story, that he was knocked down multiple times, different positions, shots were fired as if the weapon was being struggled over. All the available evidence is consistent. I mean, we'll never know what happened, right? There were only two people in the room and one of them's dead. So we can never know in an absolute sense what happened. But that's not the question. The legal question is, can the state disprove self-defense beyond a reasonable doubt when all the evidence is at least consistent with self-defense? It's not, it's so far from what the state's burden is that it's unbelievable that this case even came to trial. And this guy's been held in jail for 2.5 years.
That's a really critical element of one thing you just said, which I think people kind of get lost in these trials, and because of, and I blame my good friend Mike Boudet from Sword and Scale, and other true crime podcasts. People get wrapped up in what happened. What can we know about a situation? What is all this? And that's interesting from a drama standpoint. That's interesting from a conceptual or storytelling standpoint. It's fucking useless in a criminal defense trial what actually happened. What we can prove in court happened. Right. More importantly, what the state can prove in court happened is the only thing that matters. And that's molded by a whole lot of different rules. And does that mean that sometimes somebody murders someone and they get to walk? Yes, it does. And it's critical that we hold the state to that highest standard, even if we can all conceptually know what went wrong. We're just talking about OJ. that man chopped that woman up, right? Like that happened.
Allegedly. But he did write a book saying what would happen if he'd actually done it.
You next. You next.
But I mean, that's a great example, right? Because of us could believe it's overwhelmingly likely that OJ killed her. In fact, in the civil litigation, he lost, right? So we know a jury found by a preponderance of the evidence that he killed her. But that's not the criteria for locking someone in a cage for the rest of their life. You have to prove them guilty beyond any reasonable doubt. And that didn't happen in the criminal trial. Here, of course, the question in any self-defense case is not so much did the person do it. The person saying, I did it, I shot him. They're not denying it. They're not saying it wasn't me. They're saying, I did it, but I did it with self-defense. And once they've raised the legal defense of self-defense, the burden shifts to the state to disprove self-defense, at least one element. They only have to disprove one of those elements of self-defense beyond a reasonable doubt. But they do have to disprove at least one of them beyond a reasonable doubt. And if they can't do that, you might be 75% confident it was not self-defense. It's still an acquittal because you did not disprove self-defense beyond a reasonable doubt.
So we're still waiting on the court here. I don't know what time they're actually going to get back to this, but just to let the chat know, We are waiting. I can go ahead and start reading some of these chats that have come in. Diz Guy over on Locals says, "Dear YouTube, here is some alternative monetization." Oh, yeah. So Jeff and Andrew, I'm going to tell you my story real quick. This is yesterday I had a meeting with my YouTube partner manager. I have a monthly sort of checkup on the channel, you know, things I have questions about, or new products and beta tests are available, all of that stuff. A long time ago, it was informed to me that YouTube became aware of my channel because they have an alternative monetization team. That's memberships, super chats, things like that. And I was way, way high up on the list of that. And they didn't quite understand why, because my channel size didn't really make sense. But so I was one of the top earners in the world on their alternative monetization. And still am, even though I'm not streaming over there, still way up the list. So if you don't know, the past 3 months, I have been kicked off of YouTube for half of each of those 3 months. And then I was banned from YouTube. And then I got resurrected, the modern day Lazarus, resurrected after 3 days and come back. So this is the first time I've talked to my partner manager since that all happened. And she was great at getting me back on YouTube. But she said that she talked to the alternative monetization team. They reached out to her and asked why I wasn't bringing in as many super chats as normal. And she's like, bruh, he's been banned from the damn platform. God,
Right.
just idiocy. It's a Small Girl says, if you can please throw a sub on Rumble to the Big Empty. He's a Doom streamer who was banned from YouTube
jury instructions
for just showing news clips and vids of events.
Content or the order of the jury instructions.
No, Your Honor.
Defense team question.
No, Your Honor.
Approach the bench for a second.
Wait,
Hey,
so
Nick,
that's,
you gotta teach me how to do that copyright cooks thing. I don't know how to overlay an image like that, but I would love to have something like that, or even that one if you're willing to share. But just how to do that would be awesome.
So it's just it's a transparent image that you put in as an overlay on if you're using StreamYard, and you just have to have it positioned in the right place. My I'll have my editor. I can maybe have him make you one or something if you give me an idea.
That would be great, because I just obviously despise them too.
For mine,
as long as we're doing it, send mine my way too. Why not?
Yeah, I've got a basic one, but it's like I have the branded ones too, like with my with the logo thing up top here like this.
Yeah. Okay.
But yeah,
it's the whole thing. Okay.
It doesn't have to be though, but on StreamYard you can only have one overlay at a time. So if you want to have the branded elements plus the copyright thing, you just have to have that.
It's a separate overlay.
I'm sure Ryan, the editor, wouldn't mind making one if I got some like branding or whatever that you'd want, because he knows where to put it, so it matches up with the long crime logo. Hausfer says, I could not be this judge with two women screeching at me.
He's been great.
There's great. 4 women screaming at him. I don't know.
4.
Andrew did okay the other day.
Of the jury, what we're going to do is I'm going to read you closing instructions, and the lawyers will give you the closing statement. But I need to ask, how many of you still need to go vote? All right. So
it's election day.
This afternoon, okay? Because you certainly.
I just need to ask you: did any of you think this guy's guilty? Can we just wrap this up now?
The verdict. We'll do what we need to do so you folks can go vote. All right. All right. And Lieutenant Tomlinson is zip tying the rifle.
Another zip.
It worked so well
I'll let him
last
get done,
time.
then I'll read you. Take your time, Lieutenant.
Why don't they just have rifle locks? Like, you know, the cables that actually go through them. I mean, what? It's a courtroom.
Or good quality zip ties. I mean, they're using garbage zip ties is the problem. A good zip tie would not break.
Or maybe just go with the plastic one from the beginning.
Oh, by the way, one other thing, Nick, is during the state's case in chief, it was revealed that there was a mystery second magazine for the rifle that was introduced into evidence that no one had ever seen before. Not recovered from the scene. Just an extra AR rifle magazine.
Oh.
Yeah.
That doesn't sound shady at all.
No one knew where it came from. Just marked as an exhibit for evidence.
All right.
But the cops, most of the state's witnesses were cops, and they were terrible. They were terrible. They didn't measure this, test this, couldn't remember what happened, had no recollection of the events. None of their body cameras worked. None of the equipment in their cars worked. They didn't write things down. They didn't request for things to be analyzed. I mean, it was just a cluster from beginning to end.
Yeah. The first officer on scene, his entire report investigating the murder was 1 page.
This is just terrible. Jason of TGA says, nobody tell them about the new research that demonstrates that masks don't work and are probably bad. They might be hideously deformed under there. Very, very dangerous. Very, very dangerous.
So I had heard that this judge was actually amenable to not doing masks in the courtroom, but because the case is televised, he got a call from like Albuquerque officials saying, put the masks on.
You have heard all the evidence. It is now my duty to tell you the law that you must follow in this case. The law governing this case is contained in instructions that I am about to give you. It is your duty to follow the laws contained in these instructions. You must consider these instructions as a whole. You must not pick out one instruction or parts of an instruction and disregard others. A copy of these instructions will be given to you when you begin your deliberations. The law presumes the defendant to be innocent unless and until you're satisfied beyond a reasonable doubt of his guilt. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is doubt based upon reason and common sense, the kind of doubt that will make a reasonable person hesitate to act in the graver and more important affairs of life. You are the sole judges of the facts in this case. It is your duty to determine the facts from the evidence produced here in court. Your verdict should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide the case. You alone are the judges of the credibility of the witnesses and the weight to be given to the testimony of each of them. In determining the credit to be given any witness, you should take into account the witness's truthfulness or untruthfulness, ability and opportunity to observe, memory, manner while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the witness's testimony considered in light of all the evidence in the case. You should consider each opinion received in evidence in this case and give it such weight as you think it deserves. If you should conclude that the reasons given in support of the opinion are not sound, or that for any other reason the opinion is incorrect or not correct, you may disregard the opinion entirely. An expert witness is a witness who, by knowledge, skill, experience, training, or education, has become an expert in any subject. An expert witness may be permitted to state an opinion as to that subject. You should consider each expert opinion and the reasons stated for the opinion, giving them such weight as you think they deserve. You may reject an opinion entirely if you conclude it is unsound. In this case, as to the charge of murder in the second degree contained in count 1, there are 4 possible verdicts as to the defendant, Dean Cummings. 1, guilty of second degree murder. 2, not guilty of second degree murder. 3, guilty of voluntary manslaughter. 4, not guilty of voluntary manslaughter. You must consider each of these crimes. You should be sure that you fully understand the elements of each crime before you deliberate further. You have the discretion to choose the manner and order in which you deliberate on this count, but you must return a unanimous verdict of not guilty on second degree murder before entering a verdict on voluntary manslaughter. You will first decide whether the defendant is guilty of the crime of second degree murder. If you unanimously find the defendant guilty of second-degree murder, then that is the only form of verdict which is to be signed as to this count. If you unanimously find defendant not guilty of second-degree murder, then you should sign the not guilty form as to second-degree.
I would have objected to this. You have to first consider second degree.
You should
first consider that before manslaughter, not before
second-degree murder. You should not sign a verdict form for that crime, and you should not proceed to reach a verdict on the remaining crime of voluntary manslaughter. If you unanimously find a verdict of not guilty on second-degree murder, you will then go on to the consideration of the crime of voluntary manslaughter. If you unanimously find the defendant guilty of voluntary manslaughter, then that is the only form of verdict that should be signed. But if you unanimously find defendant not guilty of the crime of voluntary manslaughter, then you should only sign the not guilty form. If after reasonable deliberation you do not reach a unanimous verdict on voluntary manslaughter, you should not sign a verdict form for that crime. You may not find the defendant guilty of more than one of the foregoing crimes. If you have a reasonable doubt as to whether the defendant has committed any one of the crime, you must determine the defendant is not guilty of that crime. If you find the defendant not guilty of all of these crimes in count one, you must return a verdict of not guilty as to this count. For you to find the defendant guilty of second-degree murder charged in count one, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant killed Guillermo Arriola. The defendant knew that his acts created a strong probability of death or great bodily harm to Guillermo Arriola. The defendant did not act as a result of sufficient provocation. The defendant did not act in self-defense. This happened in New Mexico on about the 29th day of February of the year 2020. For you to find the defendant guilty of voluntary manslaughter as charged in count one, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant killed Guillermo Arriola. The defendant knew that his acts created a strong probability of death or great bodily harm to Guillermo Arriola. The defendant acted as a result of sufficient provocation.
Yeah, this is Cummings on Areola crime here.
This happened in New Mexico on about the 29th day of February 2020. The difference between second-degree murder and voluntary manslaughter is sufficient provocation. In second-degree murder, the defendant kills without having been sufficiently provoked, that is, without sufficient provocation. In the case of voluntary manslaughter, the defendant killed after being sufficiently provoked, that is, as a result of sufficient provocation. Sufficient provocation reduces second-degree murder to voluntary manslaughter. In addition to the other elements of second-degree murder or voluntary manslaughter, the state must prove to your satisfaction beyond a reasonable doubt that the defendant acted intentionally when he committed the crime. A person acts intentionally when he purposely does an act that the law declares to be a crime. Whether the defendant acted intentionally may be inferred from all of the surrounding circumstances, such as the manner in which he acts, the means used, his conduct, and any statements made by him.
Chat said aim for the tits.
Sufficient provocation can be any action, conduct, or circumstance which arouse anger, sudden resentment, terror, or extreme emotions. The provocation must be such as would affect the ability to reason or to cause a temporary loss of self-control in an ordinary person of average disposition. The provocation is not sufficient for an ordinary person would have. The provocation is not sufficient if an ordinary person would have cooled off before acting. Great bodily harm means an injury to a person which creates a high probability of death or results in serious disfigurement, or results in the loss of any member or organ of the body, or results in permanent or prolonged impairment of the use of any member or organ of the body. An issue you must consider in this case is whether the defendant killed Guillermo Arriola in self-defense. The killing is in self-defense if, 1, there was an apparent or immediate danger of death or great bodily harm to the defendant as a result of Guillermo Arriola Cummings. 2, the defendant was in fact put in fear by the apparent danger of immediate death or great bodily harm and killed Guillermo Arriola because of that fear. And 3, A reasonable person in the same circumstances as a defendant would have acted as a defendant did. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. A person who is defending against an attack, defending another from an attack, or defending property need not retreat. In the exercise of the right of self-defense, a person may stand the person's ground and defend himself. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agrees. Your verdict must be unanimous. It is your duty to consult one another and try to reach an agreement. However, you are not required to give up your individual judgment.
Listening to this
Each
guy
of
read
you
jury
must
instructions
decide
is
the case
brutal.
for yourself, but you must do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own view and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the
And they're so unremarkable. It's like the model penal code jury
judges
instructions. I
of
mean,
the
they're so
fact.
ordinary.
Your sole interest is to ascertain the truth from the evidence in this case.
At least he won't
You must
misdefine
not concern
recklessness.
yourself with the consequences of your verdict. Now the lawyers will argue the case. What is said in argument is not evidence. It is the opportunity for the lawyers to discuss the evidence and the law as I have instructed you. The state has the right to argue first. The defense may then argue. The state may then reply. State, you need it. Give me a second.
That's it. Wow, that was a
guy. He transitioned that in a weird way.
Wow.
I was like, why did he fucking stop in the middle of his sentence? And then I realized his last word was state.
Wow. All right. Whatever.
So we're listening for the state to disprove one of those elements of self-defense beyond a reasonable doubt. That's what they need to do.
Ladies and gentlemen, it's been a long 7 days, I think, that we've been able to all be in this courtroom together. So I thank you for your time and attention in this case. On February 29th of 2020, the defendant, Mr. Cummings, shot and killed Guillermo Adiola at his ranch in Sandoval County. As I said at the beginning in opening statements, we know who did this, and we know how he did it. And so you are the finders of fact. It's your job to determine whether or not this crime is committed with sufficient provocation, or without sufficient provocation.
God, it's so fucking quiet.
They will not use the microphones.
Did you commit this homicide in self-defense? This is your job to determine this. The state has presented all of its evidence, and the defendant has presented his evidence. We know that Mr. Cummings shot Mr. Adiola with this AR-15 rifle. With a 30-round magazine by shooting him twice, once in the head and once in the chest.
Blam!
What weapon was used?
He wasn't shot in the chest. He was shot through the chest.
What magazine was used is not an issue.
Oh, she's talking about the magazine because of the mystery magazine.
Why is this done? This is what you're asked to determine. And the state has presented evidence to you that Mr. Adiola was not armed. The force that was used was not reasonable. As I said in the beginning of this case,
This is proportionality.
And you, ladies and gentlemen, determine what is reasonable here. As I said, the judges gave you instructions on what the law is. Second-degree murder is not an act as a result of sufficient provocation. Voluntary manslaughter is when someone does act as a result of sufficient provocation. So the only difference is that number 3 for you to decide. So what is sufficient provocation? You're going to have the instructions that the judge read to you. You'll have those to look at, to read, to think about. Would an ordinary person of an average disposition have done the same as Mr. Cummings did? It's not sufficient if someone would have cooled off before acting? Would an average person have walked out of the trailer, cooled off? If Mr. Adiola was acting crazy and aggressive, was that sufficient provocation?
So New Mexico is a soft stand your ground state. We
Would
can talk
Mr.
about that more
Adiola
later.
have walked off? As I said, this is a case about reasonableness. And
When
you
she's talking about
determine what was
walking off.
reasonable on that day. So let's talk about the evidence in this case. Mr. Cummings was going to purchase this ranch out in Sandoval County from Mr. Adiola. Ms. Landers drew up that real estate contract. She's known Mr. Adiola for about 20 years. He was going to buy it for $149,000, and Mr. Adiola let him park his fifth wheel trailer out there for $300 a month. Ms. Landers told you she thought that Mr. Cummings was taking advantage of him, that this wasn't a fair deal. She said that Mr. Adiola liked Mr. Cummings, and they got along well when she saw them together. She thought that Mr. Cummings also liked Mr. Adiola as well. They were friends. Mr. Adiola had even given Mr. Cummings a horse. She said that she thought Mr. Cummings was kind of strange and something was off about him. They did not yet have an executed contract to purchase that land. Mr. Cummings told you when he took the witness stand that he also thought he got along good with Mr. Adiola. They had a lot in common. They hung out, they drank whiskey, they went horseback riding together. They got along just fine.
Brokeback Mountain.
Cummings testified that Mr. Adiola told him about an incident with a hammer. He said that Mr. Adiola had told him that he had scared a guy by hitting a car with a hammer. And he thought, hearing that story made him think, well, I better be careful. And this is a man who took the stand and told you about his vertical gains, and he made a living as a world-class skier. He told you he took multiple.
So he shouldn't be scared of a hammer attack.
Yeah.
And that this dangerous career of his required technique and athleticism.
Yeah, that
He
doesn't
thought I
involve
should
getting
be
hit with a
careful
fucking hammer.
Because an old man told me a story that happened years ago about a hammer. Is that reasonable? Mr. Cummings testified that he arrived at Mr. Adiola's trailer at about 10 or 11 p.m. the night before. He said that he was watching a movie and he dozed off. He thought that he smelled propane, and so he went to his fifth wheel trailer. Mr. Adiola arrives at the ranch the next day, February 29th, 2020, leap day. Mr. Cummings said that he believes Mr. Adiola arrived at 1:32 p.m., broad daylight. Remember, this area is so remote. Mr. Cummings could see him coming from a distance. This area is so remote, he would have heard a large truck approaching this ranch in the middle of nowhere. He had time to prepare his attack. Mr. Cummings testified about what happened that day. He told you, ladies and gentlemen, that he was in the kitchen.
No evidence of a prepared attack.
Groceries with a scowl on his face. They talked for 8 to 10 minutes, is what he told you. And that because he called Mr. Adiola a scammer, that made Mr. Adiola so mad that he attacked him out of nowhere. Just for being
Well, no, that's not out of nowhere.
Mind you, Ms. Landers believed that the contract was in Mr. Cummings' benefit. He was going to live there for $300 a month. Had full access to that land. Was given a horse for $300 a month.
He wasn't given a horse for $300 a month.
Mr. Cummings told you that he was slammed into the counter and fell to the ground. And he grabbed his rifle from the wall and crab walked down the hallway while Mr. Adiola is swinging at him, not hitting him.
Crab walked?
Swinging at him.
Like on his hands and legs?
At the beginning of this,
He just scuttled backwards, he was saying.
Mr. Adiola can't tell us what happened that day. The evidence will show what happened that day. And is it reasonable to believe that Mr. Adiola, because he was called a scammer, would attack Mr. Cummings, this professional athlete?
That's not the reasonableness question. The reasonableness is
What?
from the defendant's perspective.
Yeah,
This is a case of
misstatement
reasonableness.
of the law.
Or is it more reasonable to believe that Mr. Cummings made up this story to cover what he did?
She doesn't know, or she's deliberately
judges of the
conflating
credibility of
different
the
people's
witnesses.
reasonableness. Jurors,
Every
victims,
witness
defendants.
take that stand. You saw all of the evidence admitted. You determine who to believe. You determine what's true on that witness stand.
You decide.
You heard a story of Mr. Cummings and how what he told you contradicted every witness that took that stand. It contradicted what Mr. McCullough said happened, what Ms. Landers said would happen, what the responding deputy said would happen, what's recorded on the ballot tape of the responding deputies.
None of these people have firsthand knowledge of what happened. None of them were there.
911 calls say he disagrees. Even his own expert. His testimony even contradicted his own expert.
I don't think it did.
Why don't you say how?
Until Mr. Ardiola. He doesn't immediately run out and go get help. He doesn't think, hey, I need to call an ambulance. No. He said, I got to go wash my face and hands. And I got to go back and I got to get soap. I got to go back out and wash my hands. He changes his clothing. He walks around the ranch. He even said that he's medically trained. And he walked over, peeked in the window, and saw that Mr. Ardiola wasn't breathing. His chest wasn't moving as well as he told you guys. But he was lying face down. Mr. Cummings told you, ladies and gentlemen, that about 3:30 p.m. is the time he believes he was washing his hands off, his face, changing clothes. So if Mr. Ardiola arrived at the ranch at 1:30, what did he do between 1:30 and 3:30? That's 2 hours of unaccounted time for. Mr. McCullough called 911 at 5:30. What happened between 3:30 and 5:30? That's 4 hours of unaccounted time for. Let's talk about Mr. McCullough.
What is
Mr. McCullough testified that he was out riding.
He was a guy on a motorcycle who came on the scene shortly afterwards.
He said that he was driving at a Y intersection,
911.
right until the road ended, and he saw a male walking around outside by some structures. He said he couldn't quite look at the male.
Talking
so
trash
he
and
was trying to
truths.
keep his
Sit.
bike on
Wow.
the road.
I'll
and
read
so
your
he turned
chat
around
later.
and went back to that Cabazon Peak point of interest sign that he wanted to read. He said that Mr. Cummings came up to him while he was at this sign, and he starts talking to him about motorcycles. I like the motorcycle, telling him how he likes motorcycles. And they have this friendly conversation with a stranger about outdoor sports. He doesn't say, I need help or anything of that nature. Can you call 911? No. He's like, hey, let's talk about motorcycles. That goes to the reasonableness of his actions on that day.
how?
Mr. Cummings then drives off, not to get help, not to get cell phone service, which is 4 miles from the ranch. And then he decides, you know what? Mr. McCullough is going to be a good witness for him. So he drives back, talks to Mr. McCullough again, some more. They're chit-chatting. And then when Mr. McCullough goes to leave is when he waves him back over and says, I'm in a little bit of trouble and I need help. When Mr. Cummings took the stand, he denied that he ever left and came back. His story contradicts Mr. McCullough. So you judge the credibility of the witnesses. Mr. McCullough testified that the defendant told him he needs help. Not Mr. Ardiola needs help. Mr. Cummings needs help. He tells Mr. McCullough that he was sprayed with a poison. He never said mace. He never said I was in a fight for my life with this gun. He said I was sprayed with a poison. And the poison burned his skin and his face and made it difficult for him to breathe.
I mean,
Mr. McCullough sees no injuries. He said he didn't see anything on Mr. Cummings that night. He never told any witness that he was in a fight, that he was in a battle for his life with that gun. Not law enforcement, not Mr. McCullough, nobody. He said that he was sprayed with poison. That is the one consistent thing he tells all of the witnesses.
I don't believe he ever used the word poison.
He wants to make sure that
He says he didn't.
Witness to this can. Everyone needs to see that Mr. Ardiola had this in his hand. And I urge you, ladies and gentlemen, to fill this. Hold it. So Mr. McCullough pulls out his cell phone, calls 911, and you have the 911 calls and evidence, and I urge you to listen to them. You can hear in the fourth audio, Mr. Cummings is talking in the background. You can hear in the audio on the first and second calls, he's talking to a friend. He's not calling the 911 operator. You can hear him in the fourth audio call calling the 911 operator. So in calls 1 and 2, he's chatting with a friend. You can hear him in that call telling this friend that he doesn't feel too good and his whole left side. Something about his whole left side. But he testified that his right side is straight, to you, ladies and gentlemen. Mr. Cummings didn't call law enforcement.
She said right side and she motions to her left side.
But I mean, is that...
You
he
heard
said
Mr.
left on the
Cummings
call. He said
testify that,
right after a shoot. He said right
he was
in court
10 feet away
2.5
from
years
the truck.
later.
Mr. McCullough was 10 feet away from the truck. He wasn't asking him any questions about where the gun is and if anyone needs help. But you can hear the calls and you can hear those questions he's asked.
I know she's not talking about the actual
That's what Mr.
shooting
Cummings told you,
here.
ladies and
No,
gentlemen.
all stuff that happened after.
He said that he called his dad. And Mr. McCullough described the demeanor of Mr. Cummings on that night as calm, not at all frantic or upset. Is that reasonable?
Well, when
He
the
just shot
threat's
and killed a
over,
man and is hanging out with a stranger.
This is an hour or two later.
Is that reasonable?
The state makes a big deal out of the fact the cops didn't smell any mace residue. They were there hours after the fact.
Washed his face, and that the gun is in the back of his truck. And he told you a different story. He said that he immediately put that gun against the porch. So again, his testimony contradicts what Mr. McCullough said. Mr. Cummings asked Mr. McCullough to be his witness.
None of this is disproving any of those elements of self-defense.
And Mr. McCullough told you, ladies and gentlemen, how could I do that? I wasn't a witness.
Circumstantial supposition.
I wasn't there. Mr. McCullough follows Mr. Cummings back to the ranch to see if he could render any aid. But Mr. Adiola was past the point of aid. He said he was bluish or grayish.
So the defense needs to nail down the state's burden here.
But he wanted to make sure that Mr. McCullough saw what was in Mr. Adiola's right hand. You heard Mr. McCullough say that Mr. Cummings really wanted him to see that black canister because he wanted to make sure that he had a witness that Mr. Adiola had attacked him with the black canister.
Yeah.
Mr. Cummings was obsessed with showing everyone that Mr. Adiola had a can of poison. He needed a witness to this poison. And again, he never told anybody there was a struggle. He needed a witness to this. This was his focus.
Why don't I wrap my hand
Mr.
around
McCullough
a
was
metal
the first
can
person
and
in that
punch you
trailer after the homicide.
and
He
see how you
smelled
like
nothing. No
it?
poison.
Make her hair
no
extensions fall out.
agent.
There's a roll of quarters.
Mr.
It's a
Cummings made this
different
whole
world
thing
from a
up
fist.
to justify what he did. And you can see in that photo that can is facing Mr. Adiola. Mr. McCullough goes to Cabazon Peak to wait for law enforcement. And he said that he took out his ID because he knew that law enforcement would want it. So he was there waiting for law enforcement to lead him back to the ranch. Mr. McCullough's call was at 5:31. Law enforcement is dispatched at 5:40. And Sergeant Chris Ben testified that they met with the calling party, Mr. McCullough, at 6:26 p.m. Again, more time. Mr. McCullough isn't there, and Mr. Cummings isn't there. He's back at the ranch. There's more time there. Law enforcement goes to the ranch and they encounter Mr. Cummings at his truck.
Where he had not fled.
At the exit. And he tells law enforcement, as soon as they come upon him, self-defense, self-defense. He says
Because that's a bad thing.
He was harmed by a neurological agent. And you can listen to Deputy Walker's belt tape. You can hear him say,
If he hadn't said self-defense, that would have been the wrong thing to do.
he told
never said
Deputy Walker
self-defense
that it
at
must
the
have been
scene.
chlorophyll. And Deputy Walker testified that he didn't see any injuries on Mr. Cummings. He had no symptoms that he would expect to see of somebody who has been sprayed by a neurological agent or mace. No red eyes, no red skin, no rash, nothing of that nature. Listen to this belt tape. There's no panic in Mr. Cummings' voice.
I hope the pit
He's
bull
not
for the defense
frantic
doesn't
in any
close.
way. He doesn't ever say he's
Yeah.
going to fight for his life.
Now is the time to be
With the
disagreeable.
residents, and he said Sergeant Chris Ben hung out at the car with Mr. Cummings. And Sergeant Chris Ben testified that he had been asking Mr. Cummings for his name and his date of birth for about 3 hours. And all he would say is Dean, Dean.
This is objectionable. This charge has been dismissed.
Out there. They're not getting the calls from dispatch. That Mr.
Oh, they
Cummings
dismissed
has
this
called
one
in.
out.
Yeah.
You have to drive 4 miles down the road to get radio service, to get cell service. They're not leaving the ranch. They're there to secure the scene.
Why is she even wasting time with the identification stuff?
Even on Deputy Walker's belt tape, towards the end, you can hear the defendant tell the deputies.
And saying
"Did you
your
see the
first
device
name
in his
isn't
hand?
really
Did you see
deceptive."
the device in his hand?" He wants to make sure everyone's a witness to the device. You heard
He identified himself when he first called 911.
Deputy Harris and Sergeant Griffin arrive on
First
scene
name,
at
last
wall
name, phone number.
at about 7:30 p.m. Mr. Cummings is evaluated by EMS and released. He's not transported for any injuries from the poison or the chlorophyll or the neurological agent. They take photos of him. There's no injuries on his person that are documented in these photos. There's no rash, no redness, no bruising, no scratches from a fight.
You're not required to suffer even a scratch before you can defend yourself.
Of a fight is on his body.
She should be
His knuckles
telling a
don't have injuries
narrative.
from being in a fight, a physical
Tell a
altercation.
fucking story. This is not a story. It's disjointed. It
He
doesn't
didn't
make
tell
sense.
anybody he had any burns on his hands. Even the expert witness couldn't say what was on his hands other than there's
That's
black
doubt.
blood.
That's doubt. That's uncertainty.
Nobody knows what that is.
Nobody knows. That's uncertainty.
Hours he had from the time he killed Mr. Adiola to the time these photos are taken.
Okay.
While he's being photographed by law enforcement, he tells them that, yeah, he washed off with a hose outside after being sprayed with the neurological agent. He says his clothes are in the back of the truck. Sergeant Griffin testified that they were wet when they collected the clothes, and you can see the clothes, they're in evidence. The t-shirt clearly looks like it was folded up when it was wet. It's got the wrinkled marks on it.
This is the
Sergeant Griffin
tampering with
said he found
evidence,
nothing on the clothes he collected.
which was also dismissed. By the way, the police never
Mexican
tested
State
anything
Police
for me.
arrived to process the scene. You heard from Agent Carlos.
Even though he asked
Figueroa,
them specifically to test his
12 different
clothes, they didn't.
diagrams of the scene, and Agent Edgar Lemus helped collected evidence and took photographs. Agent Herrera stated that he collected 11 spent casings from that bedroom. Now think about that. 11 spent casings. That means
So he
that
missed 9 times?
Mr. Cummings shot that rifle approximately 11 times in that little bedroom. Now we heard testimony about 2 to the body and 1 grazed the clothes and 3 through the door. That's not all 11. Mr. Adiola didn't have a chance. He was unarmed. You have a AR.
Well, at this point, he's armed with the rifle. They're fighting over the rifle. That's why there's so many shots fired.
Not 1 shot, 2 shots, 3 shots, 4 shots, 5, 6, 7, 8, 9,
It's not the dramatic punch
10,
you think it is, lady. No.
11.
He shot. You're saying he shot 11 times when he didn't have to, and he missed 9 of them. And a distance of 7 feet.
You heard testimony that the
Sounds like a
majority
struggle.
of the casings were on the
doesn't-
side of the room with the wall. So if the shooter was looking towards the door, these casings are expelling from the firearm to the right. And the majority of the casings are along that wall there. So the shooter must have been facing the door if the casings are popping out that way.
Not
One
necessarily.
casing was on the other side of the room. There's even a casing on that plastic tote. So we know the plastic tote was there.
Right, because brass rounds ejected bounce around in a small room.
So number 3 on the evidence tag, that's the casing on the other side of the room. There was only one. If the rifle expels these spent casings from the right side of the gun from the shooter, then we know that the majority of the shots were shot facing towards the door. If the gun was upside down, like the expert said it potentially could have been, then the casings would have expelled the opposite direction. And we have one spent casing on that side. And you heard they can move around, but the majority are on the right, on the other side of Mr. Adiola's body.
They can, but that's doubt.
You saw Mr. Cummings' reenactment of what he
It'd be
believed
great if
happened
the
that day.
defense attorney was just
He said
writing those things down.
that he shot 2 times
This is
into
down.
the ground.
This is down.
Yeah.
And we heard testimony about the muzzle patterns. But when Mr. Cummings came and did
Cross-examine the defense use of force expert. They asked at least 30 times questions of, is it possible? Is it possible? That's all doubt.
He never, in his reenactment, ever said the gun was upside down.
The defense expert who is employed by the state.
More casings. Let's talk about the rest of the residence. This is the door outside to go outside, right directly across from the bathroom. You heard Mr. Cummings tell you, ladies and gentlemen, that yes, he went into the bathroom, and that he was able to, at that point, when he was in the bathroom, he was able to pull the lever back. This is not an easy task, and make the rifle ready, chamber it around. This takes affirmative effort to do that. And he's going to tell you, ladies and gentlemen, that after he chambered around, Mr. Adiola continued to still attack him. Is that reasonable? If somebody pulls a rifle, chambers around, are you going to still continue to attack that person, or are you going to go out that door? Are you going to directly turn around right outside that door and go out the porch? What's reasonable, ladies and gentlemen? He could have went to the kitchen, gone out the other door, out the other side.
Could have, but did he have
What
to?
about the rest of the residents? There's no signs of a struggle. The only one who says there's a struggle is Mr. Cummings. None of the evidence shows that.
The bedroom where the fight happened is completely disrupted.
Where's the other door? The kitchen has no signs of a fight.
Well, no one claims they fought in the kitchen.
Broken dishes. If you're a parent, you know not to leave a pot with the handle out.
Wait,
That wasn't disturbed.
what?
Yeah.
I know
Nothing on
what
the
she's
counter. We see the
saying
sunglasses.
because you can
Supposedly they're Mr.
spill
Adiola.
hot contents of a pan.
That's the only thing out of place in this room. So what's reasonable? If there was a fight and Mr. Cummings
No one
said
claimed there was a fight in
slammed
this
into the
room.
counter, nothing is disturbed on the counter.
Did he claim to be
the
slammed into
counter.
that
Those
counter?
hands Are still on
He
the
claimed
edge.
he was pushed like in the corner of the counter. That was the first shove, and then he fell down into the hallway behind him.
And the black thing on the floor is the
Bedroom.
deceased guy's
Big
sunglasses.
Right.
fight in the bedroom. You have clothing on the wall. This is a manufactured home, a mobile home. The walls aren't the strongest. If you've ever been in a manufactured home, you know that you can push them. They're flexible. There's a
Okay.
hat hanging on the coat rack, and that mirror is perched against the wall there.
Okay.
Or it could be bolted. We don't know how it's attached to the wall.
You believe that the heater was on the wall. There's no scratches on that wall. If they were in this big battle for their life and they knocked over that heater, wouldn't the wall be scratched
This is
Did
all
we have a
doubt.
wall?
over? There's no physical evidence of a fight.
He doesn't have to prove a fight.
On the other side of the room.
Wait, is she
clothes are hanging
suggesting
still.
suggesting
bit
that
of
he
clothes.
was
Don't get a lot of
retreating,
clothes on
like
that
because he was
hanger.
getting pushed from one room into another room,
The lid
getting
of
away
that
from this
plastic
guy,
bin,
and had to grab a gun when his
precariously
back was
open.
against the wall?
that wasn't disturbed either.
What a shit narrative.
Now, let's talk about this photo. You heard Mr. Brudenell, the expert, testify that the shooter must have been either between the two beds, the bunk bed and the other bed, or over by that wall. So he said that the shooter must have been here. Or here.
Technology.
Not a lot of space. If this is our room here.
The state suggested the defendant was perched on the upper bunk bed,
Here.
the one with no mattress on it.
Yeah.
There was a struggle. That stuff would have been disturbed. Something would have been knocked over.
Laying across the corpse.
The expert testified that
We don't even know if he teabagged the
Mr.
guy after he
Adiola must
iced
have
him.
been parallel to the floor. He could have been on all fours. That's a vulnerable position. He's not fighting anybody on all fours.
He could have been on all fours.
He showed it. He was shot.
If you're on all fours, it's kind of hard to fire a weapon unless you've got
Here.
5 appendages.
Right?
Pure speculation.
Right to left. And from an upward position downward. The trajectory was downward. So that means the shooter is raised above the person who was shot. So Mr. Adiola could have been on all fours. You heard that. That's not someone who's fighting. That's not self-defense. Someone on all fours. Or he could have been bent over. Again, that's a vulnerable position.
all the speculation.
You're bent over and they have a rifle pointing at you. Mr. Brudenell says that, and Olamai says that. They both said the same thing. The decedent could have been on all fours or was bent over.
If I were the defense, I'd be keeping like hash mark score of how many coulds and possibles and maybes are being said here.
I would write down the exact line. You heard
The
this.
defendant in his reenactment,
Doubt. You heard
to
this.
ladies and gentlemen,
Doubt.
he said that Mr. Adiola was coming at him, he was crab walking, holding a gun, fighting him off. How can you crab walk? He's fighting him off, and he's going on the ground. And in his
He literally showed you during the demonstration.
That's how
And yes, there are issues for reversal here on appeal, should it come to that.
Oh, yeah.
the shooter was above the person being shot. That's a vulnerable position. Let's talk about the mace. No witness ever said the mace was sprayed.
Well, nobody was there.
Maybe he was kind of unsure, and on redirect, then he said it was sprayed. He's the only one who said that. This is a self-serving statement. There's no physical evidence to support this.
Gee, that's because the prosecution witness people did not test it.
Or chlorophyll or poison.
Chlorophyll.
Law
I don't know,
enforcement
you keep saying
testified that
chlorophyll.
they've been sprayed. They do this as part of their job and training, that it can last anywhere from 45 minutes to 2 days. And you heard a lot of this in voir dire. It gets on your clothing. They also said that an excess will
How would
drip
they have
out.
heard that in voir dire? Voir dire.
No excess. Not on
That's
Mr.
how we
Adola's
pronounce it
hand,
out there out
not
west.
on
You
the
should
floor.
know that by now. It's voir dire.
It has a distinct smell.
She literally just said
Water
it can
from the
dissipate in
gas
45 minutes.
Mr. Cummings said he washed off with the hose spigot. He's just spreading it. When you put water, it just spreads it to other parts. He said he used soap and washed more. You heard testimony that Mr. Adiola was known to carry mace with a dye.
And also the opposite.
Probably not the same can of mace from that 2017 incident. Probably got another can. There's no red dye in that room. And you can look at the can of mace. It appears that there's a red dye. And I encourage you to look at it. There's dirt in there. This hasn't been used.
I don't remember anybody testifying that was a red dye. She's
Mr.
just
Cummings said
creating
it-
evidence now.
So that
It was literally dude saying, "I've never tested. I have no idea. I think it had.
justifies his
I believe it
unreasonable
might have
action.
had red
Mr.
dye.
Adiola was
Possible
not
it did."
armed. This can is
Nobody
facing the
tested.
wrong way. And in order to utilize this can, you have to lip up the top and then spray. There's no
None of
way
you are
to
using it
do
as an impact weapon.
Yeah, if you're just hitting someone with it, it's completely different.
that. No one falls over with something in your hand.
The canister was never tested for dye, by the way.
You're going to fall with your hands out.
No, what are you fucking talking about?
He was dead before he hit the ground. He was shot through the head with a rifle.
Bitch, I got shoved over. I got shoved over in high school while holding a can of Mountain Dew that I rolled and kept from spilling.
You heard OMI that would have been an instant kill. He wouldn't have survived much longer after that.
Well, instant is not longer. Yeah.
Face first and not likely to hold anything in his hand.
Why?
I don't believe we had an expert testimony
on that. Dr.
No testimony on that.
My doctor. She said that Mr. Adiola was 5'9", 199 pounds. And he's supposedly in this fight for his life with a professional athlete.
The guy used to be a professional athlete.
The first one she talked about entered at the right temple,
a professional skier.
Went through the oral cavity of the neck.
Practically MMA.
Broke 3 cervical vertebrae.
Fighting those flakes.
Left fragments in the chest. And the second shot, she said, was to the supraclavicle region. I'm not good at the science.
Wait, did they?
She's not good at the technical terms for a murder case she's prosecuting.
The first one was, she said, an
intermediate range. It shattered cervical vertebrae?
It entered the upper part of his shoulder, like by the collarbone there, and passed diagonally through his chest, through the heart.
Left in a downward trajectory.
Did she consider
as if he was lunging forward.
Yeah. She considered the possibility that with a shattered vertebrae and possible nerve damage ensuing, that his hands couldn't actually open?
Mr. Adiola, he had an injury
yeah. Well, the first round went straight through his temple, so.
Some bruising she could not age. I believe she said on the back of one of the thighs. And you have the body diagram.
They don't know the order of the shots.
Other than that, he had no scrapes. He had no injury.
The medical examiner testified to that.
From this fight. His knuckles aren't damaged from a fight. What? There's no scratches. There's no abrasions. Nothing of that nature. He has no burns on his hands from supposedly grabbing a hot barrel. The expert said that the rifle barrel
I'll give you a hot barrel to grab.
The ball of gas actually coming out, and it would have been hot.
He said it could be warm.
Dr. Gerald about the toxicology that Mr. Adiola had cocaine, alcohol, and marijuana.
That's the victim. Cocaine, alcohol, and marijuana.
Tell you how that would affect Mr. Adiola particularly.
Yeah, none of us know people who drink and become violent.
And it could cause risk taking, but she couldn't say how it affects one particular person.
This is doubt. This is a defense argument.
How the testing process goes, and she was just reading what potentially could happen to someone from a piece of paper.
Right. The state's expert
pen and papers
was doing that.
This stuff wasn't tested. There's no evidence.
Because the state didn't test it.
With drug use.
Look at the defense counsel. They're looking at each other and shaking their heads.
They're just like, let me up, let me up.
Department of Public Safety lab. She did serology.
Is Carrie taking notes? Is that what she's doing?
Yeah.
And she said that
I hope she does the clothes.
Mr. Cummings wore was tested.
Oh, she's on her phone.
Clothing that he said he wore at the time of this that was wet when it was collected had no blood on it. So that means that he was standing far enough away from Mr. Adiola when he shot him that there wasn't even any blood on his clothing.
That could be an inch away.
Let's talk about the DNA testing she did. She said that she tested the rifle, and Mr. Cummings' DNA could not be eliminated. But there was a mixture there, so he could potentially be there. But
he could potentially, the DNA, be there.
Oh my God.
You heard about the different areas of the gun that were tested, and you saw the reenactment from Mr. Cummings when he said, yes, Mr. Adiola was grabbing everywhere all over the gun. He tested multiple areas of this gun.
Not the barrel. They never tested the barrel for DNA. Yeah, Nicole Moss, the other defense counsel, is lead. She did the open.
2 DNA contributors on the mace can. Mr. Adiola was the major DNA contributor, and Mr. Cummings was eliminated. If Mr. Cummings had time to set up the scene, he could have wiped the can like you see in movies.
He could have.
just the way he wanted everyone to witness the can in the hand.
Too bad there was
Took
literally no
swabs
one to
from Mr.
testify
Cummings'
to
face
that.
and hands. There were 2 contributors. Mr. Cummings' DNA was there. Obviously, it's his body, his swabs. That's not a surprise. But Mr. Adiola was eliminated. This was a physical fight. Mr. Adiola's DNA would have been on his face or his hands if they're fighting for the gun.
That's just a lie. Absence of DNA is evidence of nothing.
They also
DNA is not always left.
the fingernail clippings for Mr. Adiola. And there was no DNA foreign to Mr. Adiola. So that
He
means
didn't
Mr.
scratch him
Cummings
like a bitch.
wasn't underneath his fingernails. There's not a fight. That's not a surprise. Let's talk about Lieutenant Tomlinson. He testified about the limitations of their radios and the CAD system and the body-worn cameras and belts.
None of it worked.
That Sandoval County is the largest geographical county, and they typically on a normal shift have 4 to 5 deputies for this huge county to cover on every shift. You heard him say that he testified at grand jury on March 19th, 2020, and he was asked on cross-examination, how can you say that drugs and alcohol were not an issue when he was asked this on cross-examination? And you heard him. This grand jury was on March 19th. He didn't have toxicology. He didn't know. He can't say that it was. He didn't have that information. He didn't have Agent Herrera's report.
But he's testifying before a grand jury.
7th. And Lieutenant Tomlinson also testified that he believed Mr. Adiola entered the room, bent and turned the other direction, entered the room.
And you looked fat? That's what happened to me.
Oh, this witness really was fat.
Because of momentum.
They all were.
He also testified that Mr. Cummings also had marijuana. And he was in the presence of Mr. Cummings for 6 hours, and he also saw no injuries.
Yeah, the victim had cocaine bags in his pocket.
And the evidence shows that this was not self-defense. The only one who says it's self-defense is Mr. Cummings.
Who else would?
He can. You saw some photos about splotches on a gun. Agent Herrera said it could be stippling gun residue. It could be cleaning oil, Agent Herrera said. The expert said it could be cleaning oil.
Could have been tested to figure out what it was.
If the defendant had just taped on the scope with electrical tape, he could have cleaned the gun. There's no evidence whatsoever what those splotches are.
Well, that's on you. No evidence is bad for the prosecution.
Yeah.
The self-defense instruction says that you need to determine whether or not there is an appearance of immediate danger of death. Does this give the appearance of an immediate danger of death?
That's a misstatement of law. Deadly force, which is death or serious bodily injury.
You're in immediate danger of death.
I would object. Because that can really mislead the jury.
You heard the expert testify they can't be aged. There's no way for him to tell if they were hours apart, days apart. If Mr. Cummings had time to put this in Mr. Adiola's hand, he had time to put those marks in the ground. There was hours unaccounted for. He didn't go get help. He didn't drive 4 miles down the road to get cell phone service. He was there for hours. Mr. Cummings, when he testified, he showed you his reenactment. This is how small the room is. Nothing's disturbed in that small room. He said he was crab walking.
That's not true. That's an outright lie.
That's a lie.
By his jacket.
The carpet was upside down and wrinkled. The stupid plastic container was open.
No
The
jacket collected.
heater was knocked off the wall.
Never mentioned until Mr. Cummings said that. Mr. Cummings said that Mr. Adiola pulled the barrel of the gun against his trigger finger. How reasonable is that?
Pretty damn.
In a fight for a weapon?
Pulling the gun by the barrel against his trigger finger.
Do that again. Do that.
Burns on his hand. His hand would have been shot.
Maybe.
Is Mr. Cummings
Not from one round.
Pull the gun against your trigger finger. This story's not reasonable. His story. It's a self-serving statement made up to justify what he did, and you determine.
You didn't
credibility
actually
of it.
lay out what he did,
His
though.
story contradicts.
Like Andrew
everything
said,
that every
you
other
made a
witness
defense
said.
argument for your
Every
closing
piece
statement.
of audio we have. This is not self-defense. It requires that he was in fact put in fear by the apparent danger of immediate death or great bodily harm.
Oh, now she adds great bodily harm.
There's no immediate death. There's no great bodily harm. His actions weren't reasonable. And we would ask that you find him guilty of the second-degree murder.
Oh, it's over. Thank God.
Mr. Adiola was unarmed.
But my jaws.
He
are
wasn't
hurting from
unarmed.
clenching my teeth. Yeah.
He was armed with mace and then trying to arm himself with a rifle.
Thank you.
Oh,
My
thank
jaws
God.
were clenched from stress.
All right, who's going
God.
up? Who's going up? Is it Carrie?
Yes.
Is it
Yes.
Carrie?
Yes.
Are they just talking? So the shorter defense lawyer, Nicole Moss, is lead. Carrie works out of her office. Oh. I knew it when I saw Carrie on her phone. Look at that list of notes. That's a lot of papers. Ladies and gentlemen, jury, prosecutors, a cunt.
Your Honor. Counsel. Ladies and gentlemen of the jury. It's almost like the prosecutor was watching a different trial than the rest of us.
Uh-oh.
Because the state's case, after all of this evidence has been presented, boils down to a bunch of could-haves, hypothetical scenarios, and excuses. Excuses for why they didn't do the criminal investigation that should have been done in this case. The type of criminal investigation that the state has an obligation to do. Because the state, the law enforcement agencies, and we've got two of them in this case. We've got the Sandoval County Sheriff's Office, and we have the New Mexico State Police. Two agencies that could have and should have done a thorough, unbiased investigation. And instead, what we have is this half-hearted, sloppy, I'm sorry to say it, sloppy, incomplete investigation. And now the state's asking you to prosecute and convict Mr. Cummings of murder. Let's talk about what the evidence actually showed in this case. The evidence that you saw during this trial. The state started its case with Officer Walker. Officer Walker, who seems like a nice enough guy.
This is a good way to do this already.
His entire law enforcement career skipping from one agency to another, to another, to another, until now he's not even in law enforcement anymore. Officer
Three
Walker
agencies
was,
in 5 years. Now he works
sounds
for a
like the
friend.
first person who had contact with Mr. Cummings that day. When the police finally arrived on scene, took them a while to get there. Mr. Cummings waiting patiently for them to arrive. And Officer Walker testified on direct examination that Mr. Cummings refused to provide his name and that he had asked Mr. Cummings his name and he wouldn't tell him. As you may recall, my co-counsel asked him to listen to his entire bell tape. We took a break for the night, at which time he did. And then he had to come back into court and he had to tell you, he had to admit that his statements were not true. He actually never did ask Mr. Cummings his name. So that's our first state's witness.
Well, second.
He also denied that Mr. Cummings ever said, "I'm devastated." Denied that he ever said that. And my co-counsel again had to play his recording back to him so he could listen to it. And you could all listen to it again. When it is as clear as day that one of the first things that Mr. Cummings said to those law enforcement officers is, "I'm devastated." And yet the state wants to spin it like he was having no emotions at all that day. The state ignores the fact that during the 911 call made by Mr. McCullough actually says
that Mr. Cummings seems pretty shook up. It's in the 911 calls. You have them. If you want to listen to them during deliberations, you may do so. So even Mr. McCullough says he seemed shook up, and then he describes himself as devastated. But I'll give Officer Walker credit. At least he was running his belt tape. At least he was running that recording device. Because in this case, I think it's become really clear why it's so important that law enforcement have recording devices whenever they interact with the public. It's so important because just with Officer Walker, we saw these numerous inconsistencies and inaccuracies in his testimony that he had to be confronted with using his belt tape. And so at least he was running it. Another law enforcement officer ran a recording device out at the scene. Officer Crespin says he was running his lapel camera. He says that he was running it and he made multiple videos throughout his investigation that day. And yet somehow, oddly enough, that is the one case where his videos disappeared. I told you about how he would download all of his videos once a week. And he admitted that all of the videos from that week, that included February 29th, all of the other videos from all of his other calls that week were downloaded. Crazy. All of the videos just for Mr. Cummings' case disappear. No explanation for that, and I don't have an explanation for that. Either he was not telling the truth when he said he was running his camera, or they were destroyed or lost.
Against the state.
Officer Crespin is also the officer who doesn't even know what time the sun sets. He couldn't tell us accurately when the sun had set the day before.
Yeah, he said the sun sets at about 10 o'clock or 10:30 in February.
And believe that he actually was interrogating Mr. Cummings and asked him for 3 hours what his name was, and that he didn't know his identity, despite the fact that Mr. Cummings had actually called 911, had given his name, had given his phone number, and told the 911 operator, I have been attacked. Attacked. Where's the 911 call Mr. Cummings made? Why do we have 4 911 calls from Mr. McCullough and we don't have his? We don't have Mr. Cummings.
Objection, Your Honor.
No.
Objection. They're really doing a lot to raise doubt about the investigation and our work on this case.
It's really outrageous that the state's objecting here. There was so much they said that was objectionable, misrepresented the evidence. And the defense never objected. There's Kerry. Yeah, that's bullshit. That's bullshit. No.
As I was saying, ooh, she's gave her a eat shit and die look.
As I was saying.
Obtained Mr. Cummings' 911 call. Why not? They can clearly get 911 calls because they got Mr. McCullough's. Why not get his? Then moving on to Sergeant Griffin. Sergeant Griffin was the investigator at the scene responsible over the investigation of the ranch. Sergeant Griffin came in here, ladies and gentlemen, told you this was the magazine recovered from the scene, and these were the casings recovered from the scene. Their lead investigator on scene tells you this. It's not a big mystery that this is not the right magazine. This is the right magazine. Why do we have 2 magazines? The state doesn't even know what their evidence is, and we don't know where this stuff comes from. I'm going to oppose. I'm sorry, but...
You fucked up, woman. Sit the fuck down. I'm getting upset here.
No, the defense is to tell the judge, you can't keep letting them do this.
Yeah.
This is actual evidence presented to the jury in court. They're not doing anything surreptitious here.
Yeah. Wait, why don't we get to point out that they brought this into court and like what could the objection be here, Your Honor? They brought something into court that isn't real, like that no one can verify.
It states evidence.
She's just doing this to break up the flow of the argument. I mean, there cannot be a legitimate argument being made there right now.
No. You go back again, as I was saying.
This is the magazine. We know this because Mr. Cummings told them exactly where they would find it, and that's exactly where they did find it, on the porch steps. That's Sergeant Griffin for us.
Shit. Damn.
I hope she goes in on Coma Guy hard.
Sergeant Griffin also testified that Mr. Cummings told him where his clothes were located, told him he had been attacked and sprayed with some kind of a chemical, and asked him to tag those pieces of clothing into evidence and to test them. None of that was done. The testing, obviously. Then we hear from Officer Herrera with the New Mexico State Police, our second law enforcement agency on scene. Officer Herrera described how when he went out to the scene, he did some preliminary investigations. We see the photos that were taken. We see the evidence markers. Mm-hmm. And we see some trajectory rods. What we don't see, though, is a complete shooting reconstruction. The state never did that. They have people, they have a whole Department of Public Safety that could have done a shooting reconstruction. Why didn't they do it? Instead, it was left to the defense. We had to hire a shooting reconstruction expert, Aaron Brudenell, and ask him to try to piece together the scene based upon what had been collected by the state police and by the Sandoval County Sheriff's Office. But a lot more could have been done at the scene, and it wasn't. And ladies and gentlemen, I would submit to you that the reason the state didn't do a complete shooting reconstruction is because it wouldn't have helped their case. Because once we saw the complete shooting reconstruction, we see that it actually
a good diagram here.
proves Mr. Cummings is telling the truth. I apologize. I should have gotten this set up before I started.
Yeah. Terrible of you.
So what we see once we finally do a shooting reconstruction is a scene that is chaotic. A scene with impact sites showing that this gun was on the ground upside down when at least 2 shots were fired. Who intentionally kills somebody by laying on the ground, turning their gun upside down, and shooting? The state seems to be trying to suggest that Mr. Cummings could have done that after he shot Mr. Arreola. Again, could have, without an answer is reasonable doubt.
Indeed.
It's also ridiculous, quite frankly.
Shout it, sister.
And you heard Mr. Brudenell explain why that scenario was incredibly unlikely. He would have had to have pretty much laid across the body in order to achieve that. And as the state pointed out in their own closing, there was no blood on his clothes.
Nice.
Laying across Mr. Arreola's body when he's lying there bleeding out, shooting this gun off at this incredibly odd angle and location, and not getting any blood on him. Again, this is just sheer speculation by the state. Moving on. our case agent, Lieutenant Tomlinson. Lieutenant Tomlinson oversaw this entire investigation from his office. He never went to the scene. He never bothered to order the testing of Mr. Cummings' clothes. He never bothered to have the gun tested for traces of mace. He never even bothered to speak with Carlos Herrera. Instead, he went before the grand jury and he testified to a series of statements that were not true. He then comes in here and testifies before you all and explains that he was in a coma last year and therefore he can't remember his grand jury testimony. But he can remember the details of his investigation just a few weeks earlier. And whether he can remember the grand jury testimony, whether he can remember the investigation or not, doesn't really matter. Because the fact that he may have been in a coma a year ago doesn't explain his lack of investigation 2.5 years ago. It doesn't explain his grand jury testimony 2.5 years ago. We also heard from Dr. Jarrell at the Office of the Medical Investigator. Dr. Jarrell is a professional. She is a forensic pathologist. She comes in here and testifies as to the facts as she sees them. What she did not do was testify that Mr. Arriola was on his knees. She did not testify that the shooter was over Mr. Arriola. In fact, she said she doesn't know where the gun was. She's not going to speak to where the shooter was. All she could testify to is the trajectory of the wounds and basically the toxicology results. She told you. She also never testified that Mr. Arriola would have dropped that can of mace when he was shot. There was never any testimony about that.
Yep.
That is all the state. Spinning the facts to suit their needs.
The state speculated that in a question.
What Dr. Jarrell did testify about that is important. I think it's very clear why it's so important now is the fact that Mr. Arriola was intoxicated. He was a 0.118. For context, the legal limit for driving while drinking is a 0.08. So Mr. Arriola was over the legal limit for alcohol at the time of his death. And he was using cocaine, and that the cocaine and alcohol were used close enough in time that it actually combined to create a different substance called coca-ethylene. Coca-ethylene in the body can increase aggression and risk-taking. She testified to all of that. And then we heard from the state's DNA analyst, Ms. Otto. Ms. Otto testified that Dean's DNA was found on the gun. Of course, it was found on the gun. That makes sense. It's his gun. He never denies handling it. She also testified that when they tested the gun, when they're swabbing it, looking for DNA, they didn't swab the scope at all. They didn't swab the muzzle at all. All of their swabbing was focused down here, which is consistent with what Mr. Cummings was saying, where he was holding the gun and where Mr. Arriola was grabbing for the gun. Mr. Arriola was grabbing for the gun here and here, ripping the cap off the scope. So no wonder they never found Mr. Arriola's DNA on his firearm. They didn't test the right places.
I love the detail of ripping the cap off the scope.
Yeah.
The way the prosecution laid it out makes it not, like, oh, well, it may be fought over. And then here she is. No, it's ripping the cap
Cummings'
off the scope.
DNA
this is a grab. This is a violence.
Was never found on the mace canister. And by contrast, this is small. This is compact. Ms. Otto testified that when they would swab something like this, they would have swabbed the whole can. They were able to get all around it because it's small compared to this. And Mr. Cummings' DNA isn't on here. Mr. Ariola's is, of course, because as we now know, Mr. Ariola loved his can of mace. We also heard from Mr. McCullough and Christine Landers. Mr. McCullough came in and he told you what happened that day to the best of his memory, testified that Mr. Cummings was pretty shook up. We have no dispute with what he testified to. Ms. Landers, you heard her testimony. You will ultimately be the judges of credibility. Ms. Landers, it appeared that she was looking for a quick buck. She wanted this real estate contract signed quickly. She didn't want to bother with other agents or allowing Mr. Cummings the opportunity to speak with a lawyer. She wanted him to sign that contract that day, right away. She was even annoyed that he read the contract. She didn't even want him to read her contract, and she certainly wouldn't give him a copy of it. She also claimed she knew Mr. Ariola for over 20 years. Apparently, she didn't know the same Mr. Ariola that everyone else did. Because let's talk about some of the people who really knew Guillermo Ariola. Debbie Dominguez and Joe Chavez. And remember, these are people.
These are neighbors who grew up with them. Grew up with the victim.
They came in.
Best friends.
We talked about the real.
With friends like those.
How they were both maced. Multiple members of their family were maced. No dye in that mace. He even maced their dog. And then you hear from Mr. Klinger. Mr. Klinger, who doesn't really know anybody. Doesn't know anybody. He was just there to buy some medical equipment. Mr. Klinger's only connection is the fact that he had done a couple of transactions with Joe Chavez for sounds like some kind of medical devices or some insulin because they both were diabetic. And he testified that he had just pulled up to the gate and was waiting to be let in when all of a sudden Mr. Ariola comes up and starts attacking his car with a hammer. A hammer. Never met the guy before in his life, and Mr. Ariola breaks out his tail light and is banging the hammer all the way down the side of his car. He gets out to say, "What are you doing?" And Mr. Ariola holds the hammer back and says, "I'm going to F you up." That is the real Mr. Ariola. Unfortunately, that's the Mr. Ariola that was out at the ranch that day. That's the Mr. Ariola that attacked Mr. Cummings. Mr. Chavez made a statement when he testified yesterday that really struck me. And I'd submit to you, ladies and gentlemen, to consider this. Mr. Chavez said that Mr. Ariola was only aggressive when he was drunk, or when he was intoxicated. But he was intoxicated every day. That is the Mr. Ariola.
Cheers to the deceased.
That attacked Mr. Cummings.
I resemble that remark.
Mr. Cummings got on the stand and testified and told you all what happened. He also told 911. He told Mr. McCullough. He told the police when they arrived on scene. And he told you that he acted in self-defense. Can't see this too well, but you will be able to see it when you go to deliberate. This will go back with you. This is the instruction for self-defense. And what I want to point out to you, ladies and gentlemen,
burden,
is that the burden is on the state to prove by a reasonable.
It's almost as if you have experience dealing with self-defense things.
Act in self-defense. The burden is on the state. It's not on us. We don't have to prove he acted in self-defense. They have to prove he did not.
Beyond a reasonable doubt.
I'd submit to you that not only did we prove beyond a reasonable doubt, we proved beyond all possible doubt that he acted in self-defense. Let's talk about what the evidence shows there.
Do that again. Do that again. Do that as many times as you can.
When he testified, the relationship that he had with Mr. Ariola. He described that they got along pretty well. They spent a lot of time talking about the ranch. They went horseback riding together. They even spent a night drinking whiskey. Of course, it was the night that the two of them were drinking whiskey that he started to see some red flags with Mr. Ariola, when Mr. Ariola started to share stories about his neighbors. Now we can see why Mr. Cummings would have been a little bit apprehensive about getting crossways with Mr. Ariola after hearing the stories about those neighbors. But Mr. Cummings tried to continue to get along with Mr. Ariola because he wanted to buy that property. He really wanted to get that land, and he wanted to build his home and his guiding company. He had no motive to kill him. Killing Mr. Ariola kills the land deal. So the state cannot present to you any sort of a motive for why he would have killed him. And you don't have to take Mr. Cummings' word on how things happened that day, because the physical evidence actually does show you that he acted in self-defense.
Yep.
First, starting out in the kitchen, the state's trying to direct your attention over to like the living room area and saying there's no sign of a struggle in the living room. Well, of course there's not a struggle in the living room. We all have heard the struggle never happened in the living room. I don't know why they keep trying to direct your attention there.
Yeah, I wonder why.
But what we do see are Mr. Ariola's sunglasses laying on the floor right at the location where Mr. Cummings said this all started. Right where he was attacked for the first time, right here, next to this counter. And he's described for you when the very first time Mr. Ariola attacked him, he went down on the floor. He didn't go flying over to the stove. He didn't go across the room to the living room and start tearing that up. No, he went into the hallway. And he described for you how when he went down, his firearm happened to be sitting right about there. His firearm that he was preparing because he was going to go hunting. And when Mr. Ariola attacked him and was over him, he grabbed the firearm away from him. He grabbed it away from the wall in an attempt to defend himself.
Ariola had the sunglasses propped on his hat. That's where they fell off.
And he described for you how the fight went down the hall, how he was knocked down again by the bathroom, and he tried to get up, and he did get up. And at that point in time, he held the rifle and pointed it at Mr. Ariola and said, "Stop." He was trying to stop this attack, but Mr. Ariola didn't stop. And the state's arguing that's not what a reasonable person would do. That is correct. That's not what a reasonable person would do. But what we all know now is that Mr. Ariola wasn't always a reasonable person, especially when he was drunk and on cocaine. Far from being reasonable. The fight continued into the bedroom, and we hear
attack
about how he was tackled again.
Looks like the defendant's whole face is quivering under that mask. Another reason they shouldn't have these masks.
For a third time in the doorway of that bedroom. And what do we see? What do we see there? The state says there's no physical evidence of any sort of a struggle.
Those were all
What do we
bullet
got right
impacts
there?
on the floor, Nick.
We've got a propane heater
Those are the bullet
knocked
impacts?
off the
Yeah.
wall. See the brace that holds that heater up. Knocked off the wall,
And they're
laying
roughly
on its
directional,
side.
so you can imagine him backing up while he's fighting over the rifle,
What is that if not
coming around the
signs
corner.
of a physical struggle? And then the struggle continues in the bedroom.
Those are the best struggle.
And as we've already heard, ample testimony, and we've seen the impact shots. Two shots go off with the gun upside down on the floor, completely indicative of a physical fight over that gun. A struggle for the gun that's going to result in one person living and one person dying. Mr. Cummings did not want to be the one who died. A physical fight where Mr. Cummings is retreating away from Mr. Areola back into that tiny bedroom. And the state's going to make a big thing about how small that bedroom is. Ladies and gentlemen, I submit to you, that makes it all the more credible that Mr. Cummings would feel in danger for his life. He wasn't in some big room that he could retreat even further, which, by the way, the law in New Mexico is that you do not have to retreat. You can stand your ground. But despite that, he did keep retreating. All the way down the hallway, he kept retreating until he gets to this tiny little room where he can't go any further. He can't go any further. He is trapped in that room with a crazed man attacking him over and over again. And you could see the rug pushed up, bunched up, to where Mr. Cummings couldn't go any further. He had nowhere else to go. The gun is already going off. It's already shooting stuff all over the place.
Her phone's going off. Oh, shit.
The gun's already been shooting bullets all over the place. As you hear from Mr. Brudenell, it was a chaotic scene. We have at least 3 different angles of gunshots at that scene, indicative of a struggle. And finally, what we have in this photo, you could see where the scope cap was ripped off the rifle and ends up under Mr. Areola's body. Ripped off.
Broken.
Under his body. That's critical. That is completely consistent with what Mr. Cummings described.
And it was in the blood, so the defendant would have had to put his hand in the blood if he were going to be sneaking in there after.
On the scope, and he's pulling so hard that it doesn't just tear the cap off, but there's electrical tape to make it even more secure, and it breaks the cap. It breaks the cap and lands under the body. And finally, what do we find in Mr. Areola's hand? A canister of mace. The state is trying to make a big issue out of the fact that Mr. Cummings was describing it as a poison. Maybe he called it a poison. Neurotoxin, chlorophyll. If Mr. Cummings had planted the mace in Mr. Areola's hand, wouldn't he know what it is? Wouldn't he say there was mace in his hand? Instead, he's describing it all these different ways because he doesn't know what it is. All he knows is that there was something black and hard that he was being attacked with over and over and over again.
Where's Drex when you need him?
So many jokes. I'm going to die.
Because we know now, Mr. Areola liked to attack people with mace. Now let's talk about Mr. Cummings' behavior after the shooting.
Exactly the wrong time to take a
Cummings
drink.
Immediately ran out, washed his face, washed his hands. Still burning. That's consistent with the testimony we've heard that water isn't a good way to treat Mace. He didn't know that.
You don't want to get that stuff in your eye.
So he ran inside and got some soap, came out and continued to wash his face. Took a while for the burning to stop. But once the burning stopped and once he could breathe again, what did he do? Ladies and gentlemen, I would submit to you that every action Mr. Cummings took after this shooting are the actions of an innocent man. We're out in the middle of nowhere. There's nobody around this ranch. If he had actually just murdered Mr. Ariola, why didn't he just leave? No one's there. He could just say, I have no idea what happened. Why did he stick around? Why did he wave down Mr. McCullough? Why did he call 911? Why did he wait hours for the police to arrive? Why did he gather up his clothing and put them on the bed of his pickup truck? Why did he put the gun and the magazine on the front porch steps?
Why did he say self-defense right away?
Why did he do all of that? He did all of that because he acted in self-defense. The state's making an issue out of the fact that he asked Mr. McCullough to be a witness for him. He explained to you why he wanted a witness. He was scared. They were out there in the middle of nowhere. He had just shot a man. He knew that police were going to arrive because he asked the police to be called and he called the police himself.
He was afraid he might be locked up for 2.5 years on shitty evidence, which is exactly what happened.
That's reasonable. He knew they were going to have guns drawn on him. So he wanted a witness not only to what had happened at the ranch, but he wanted somebody there to be a witness to the police. And Mr. McCullough was that. Mr. Cummings did everything he could to assist the police in their investigation. Despite everything he did, the police still didn't do a complete investigation. They gathered the clothes, but they never test them. They take the gun, but they never test it for mace. They never even tested the mace canister. They never even called the mace manufacturer to ask if this had dye in it. The state's asking you to look at this mace canister and decide that it has some kind of dye in it. There's no evidence of that. And in fact, this looks more like rust than any sort of a dye. And the testimony we've heard from the two people that actually were maced by Mr. Ariola is that the mace he used didn't have dye in it. But regardless, the state could have tested these things. The state actually did do a little bit of testing of the firearm. You heard Mr. Brudenell describe for you how they did some basic firearm testing to make sure that it operated. They tested the gun to make sure it worked. How is that helpful?
We know it worked.
What does that tell you about this case? Nothing. We already know the gun worked.
Another gun.
He used the gun to shoot Mr. Ariola. So that wasn't in dispute. All that shows you is that the state is capable of doing testing. They just chose not to.
The next step, and the fact that they chose not to, should not be held against our client.
Of proving beyond a reasonable doubt that Mr. Cummings did not act in self-defense.
Yes. Yes.
Yes. All of the evidence in this case, all the physical evidence, everything that you have seen corroborates Mr. Cummings.
Yes.
Corroborates the fact that he was attacked.
This should be the close right now.
Not once, not twice, not 3 times. Repeatedly, over and over and over again. He was attacked by Mr. Ariola till the point where he was up against almost a wall. He was up against those beds with this man over him. Still coming at him, and that he scrambled up to his feet, and you see from the way the rug is all bunched up right where all of this happened, he's scrambling to his feet, pulling on the gun. And he even tells you how at one point he decided, Dean, if you don't get serious, you're not going to be a dad anymore. And he then takes his other hand, his left hand that he had been using to block Mr. Ariola's strikes. At that point, he realizes this is it. This is it. I need to get serious or I'm going to be dead. When that happens, he grabs the gun with his left hand, raises it up, and shoots at Mr. Ariola as he's coming towards him again. The trajectory of those bullets shows that right to left pattern in a downward position that is completely consistent with someone attacking. He was attacking Mr. Cummings at the time he was shot and killed. The state tried to suggest that Mr. Ariola was an old man. He wasn't an old man. He was 47 years old at the time of his death.
Yeah.
47. Younger than Mr. Cummings. Ladies and gentlemen, the state's going to make their rebuttal closing, and then the case goes to you. At that point in time, the power is going to shift. The power that the state has and law enforcement had when they conducted their investigation shifts to you. And then you have the power to review their investigation, review their prosecution. And you have the power at that point in time to take the facts, look at the law, and render a verdict. And I would submit to you, ladies and gentlemen, that all of the evidence in this case points to only one verdict, and that is not guilty on both charges. Thank you.
On the grounds of self-defense. Ugh. Finish it. Finish the sentence.
If that's the worst criticism, she did pretty well.
No, she did good. It was solid. I'm hypercritical in my area of expertise. Oh my God! Now we got the other Karen coming up. They're both
right. I love rebuttal. I hope they tag team it.
This is the woman who did the reenactment with the rifle. This was the blueberry.
No, so when we move forward, it's there.
You know, these two women hate each other in real life. They'd have to.
They'd have to.
Defendant said there is no future without peace.
I'll get to the Rumble rants when they're done, by the way, guys.
This is a man who sees there's now
What the fuck?
very dangerous. But he wants you to believe he wants you to believe
Oh, object already.
that this item, very light, if you can feel it. But he was so afraid, even though he was blocking it, he was blocking it, he was blocking it. Why couldn't he knock it out? Very light. Let's see that. Very light.
And Ms. Moss also asked, why would he say it was a neurological agent? Why would he say it was poison?
Because he doesn't know.
Well, I suspect he's figured out.
Do you have a narrative structure to your argument at all? Like, why?
This self-defense to work, he had to have said it was something other than deadly, something that wasn't deadly weapon, like poison or neurological weapon.
She did this with witnesses too. It really bothers me how she closes proximity on the jury like this.
Oh, Jesus.
This to repel this. And you'll get a chance to peel this weapon. Very heavy. You heard his testimony. You saw his demonstration, which didn't match the testimony.
All right, so they're trying to make a proportionality argument here, but it doesn't work.
How?
No, they were both wrestling for that weapon.
Upside down, crawling away, and this this would have been on the ground, that's what he said, he's using this to fall backwards. And he's still blocking with this? Well, how's Mr. Guillermo even trying to get the weapon if it's so close to the floor? Was he all the way down trying to get the weapon?
Well, as per your demonstration, it was when he was standing up.
He kept saying that he was over me. He kept trying to take me over. And
She walks like Caitlyn
you'll
Jenner.
recall in Ms. Mott's opening statement, he testified a little bit, excuse me, differently than what she said happened.
She just lumbers.
We need to get Rob on the case.
It's like she just got off a date with Drex.
Oh, Jesus. Mine was a law and lumber joke.
He was being stuck with this thing. And Mr. Arya said over and over and over again. Words matter. And what he said and didn't say also matters.
Sounds like she just got done with
There's another
Drex.
date joke in there somewhere.
We always have the burden of proof. I'm glad we embrace that burden.
We embrace it like sweet death.
Nice team did a great job. Outstanding job. But when something doesn't make sense, it's not true.
What? That's not how that saying works.
That's actually not true either.
And they don't have to put on a case.
Lots of true shit doesn't make any
But
sense.
once they do, once he takes that witness stand, the same instruction you use for credibility for the witnesses, you use for him.
Okay, fair enough.
You take into account his truthfulness. Well,
He looked fine on the stand.
I disagree a little bit with Mr. Moss. Nobody can prove 100% or beyond a reasonable, or beyond all possible.
Oh!
That's not the instruction.
Paging Dr. Freud.
Two people that know what happened. Two. Defendant and Mr. Adiola. And he's not here.
Yeah, that's a problem for you.
To tell you
They forgot what side of the
talk
argument they're
about
on here.
possibilities and
They
scenarios.
never
but
knew.
Evidence doesn't necessarily show what they're saying.
Doesn't necessarily.
This is how small that room is. And keep in mind, there were bunk beds along this wall. Right? He comes in, and there's a bunk bed down there, and there's a coat thing down there.
What is she talking about?
It's more likely that Mr. Adiola said, hey, where the hell are you? Or where are you going? Where are you going to the bathroom? Comes in, bang, bang, bang. What's the person going to do when they hear shots? And both his expert and OMI did say that it could have happened.
It could have.
Mr. Adiola could have been on his knees.
Could have.
And when he was down here demonstrating, and I think I asked him twice, when you actually shot him, show me how was the weapon. And by the way, just so no one gets nervous, I was well aware yesterday that the weapon was clear because
Oh, were you trying to make up for that fuck up, you idiot?
but he was pointing like this. He was pointing out because he had to for the story to make sense, right? Because Mr. Adiola is still trying to do this. He's leaning over him, striking him. And he said he'd do like this.
I'm never going to forget the prosecution suggesting the defendant was crunched up in that top bunk. shooting down like from a sniper in a perch.
Gunshot wounds that killed Mr. Ariola. Down. Slightly down and to the right.
Her box of wine is about 2 foot cubed.
There's
18
no way
gallons of rosé.
that if he was coming straight at
Finish it tonight and open the same box.
there is no way that he could have been coming straight on to get this shot and this shot. Wrong side. This shot and this shot. No way.
Jesus, woman. I figured out what it is. She doesn't move her arms when she walks.
That's important for a lot of reasons. He's scooting back.
That armpit hair catches on the cloth.
Oh.
Chafing.
Explain if he was scooting back, if he's scooting back and he fell and the defendant certainly didn't indicate that he moved the body. He fell right there, he said, at his feet. There's not even any room, and he would have had to have been up higher. And if he was really at his feet, common sense, ladies and gentlemen. Look at all that blood. You tell me how it would be possible that he wouldn't have gotten blood on himself.
Well, the guy that's just
I don't think he has to explain anything, really.
Within feet or inches, depending on where you believe he was when he shot.
This is rambling
But
nonsense.
we know one thing for sure.
Like,
We
I haven't
know
followed a word of what she's
that
saying.
the shooter, the defendant, had to have been above, or at least the weapon had to have been above Mr. Ariola when he was shot.
no.
Didn't fit his theory.
He could have been lunging.
Red herrings.
I like the
I'm sure y'all
sniper
know
in the
what red
top bunk
herrings are.
argument better.
You know, it's when
It's
there's things thrown at you.
does this look
or
like late
put in front
2000s
of you
Martha
to
Stewart to
distract
anybody
you
else?
Yeah.
from what's real.
Finally, a classic
You don't
prosecutor's
look
argument.
at the things that don't make sense. You don't look at all the times that he told me.
Pay no attention to that
Remember,
reasonable doubt.
when I would ask him about stuff that he knew clearly didn't make his story work, I don't remember. I don't recall. In fact, I believe a total of 22 times. I don't remember. I don't recall. Mr. McCullough said you didn't tell him right away. I don't recall that.
Gee, what did coma
Mr.
guy? How many
McCullough,
times did he say? I
Just
don't know.
breathe.
somebody else, and you could. The conversation was. I don't remember that. I don't recall that.
Yeah.
Mr. McCullough said, "I'm going to go back to meet the deputies. I'll be right behind." Will you, and he said, "I'll be right behind you."
I'm gonna,
I don't
I'll be,
remember
I'll be there.
The
finding you.
deputies testified. And by the way, just to clarify, deputy, maybe it was in the inartful way I asked the question, but I believe what I asked Deputy Walker was, were you aware, is it normal to try to get identity of a suspect? Yes. Are you aware that attempts were made? Yeah. They're all standing around there together. So he was aware of it. Deputy Crespin said he spent hours. What's your name? What's your full name? We need all of your identifiers. We need your date of birth.
This is objectionable. This charge was dropped.
It says on his testimony, for what?
And this is rebuttal.
But why wouldn't you just tell them, even if you've already told 911?
Because you don't have to.
Paul said, a reasonable man Well, when they approached me, they didn't even have to ask for his ID. I got my license out. So I know that's what a reasonable person does. And the only reason why he wouldn't
that's not what's supposed to be reasonable here.
Would be
it's whether he acted in self-defense reasonably.
because he didn't
doesn't have to do
want him
everything
know the full
reasonably.
identity for some reason. I don't know, but he was obstructing the law enforcement. They had no reason to make that up.
That's objectionable. There's no obstructing charge.
If you believe the defendants and defense counsel, there's a big conspiracy going on.
Just incompetence.
Between the deputies, the CAD operators, I guess. Remember, he called a different agency.
Unless that jury box is full of 12 cats, she's got a serious problem.
He called 13 minutes after, when he already knew David McCullough was on the phone, back and forth with Respect, because the calls kept being done. Well, they must have.
This is like watching Joe Biden speak.
Whatever the heck that means. And where was he going? When
you know she's on Tinder, right?
Mr. McCullough? I don't know. Why would he even put the wet clothes in the back of his truck instead of leaving them there?
She's double masked.
Why would he put this weapon that he had just killed someone with in self-defense in the back of his truck under his
She's
clothes?
double masked.
And that was a testimony also.
Why did she do that?
Same reason they always do it. It's, cult signaling. I wonder if there's a juror who's double masked.
Remembers or not, Mr. McCullough remembers. Where was he going? And why, all of a sudden, after they went back to the port, they went back, when Mr. McCullough followed him back to the ranch to see what had happened, propped up against the thing when the deputies got there. It was propped up against.
These rhetorical "why would he do X" questions do not lay out a state case for murder.
She argues like every ex-wife ever.
But he did, if you believe Mr. McCullough, who has no reason to lie.
At least one that I can think of.
After he went back and ran into Mr. McCullough. So where was he going to? Fleeing the scene? Now, again, he doesn't remember.
Kids, remember, if you don't have a double mask available, you can just grab your local plastic grocery bag, put that over your head, and tighten it up. Keep the COVID out.
And he turned around like a second thought and said, you know what, I'm in trouble. I need you to come witness the body. Not how somebody who just acted in self-defense against a person that he was supposedly friends with. Yeah,
you're friends until you're not.
And actually, Officer Walker did not say. He said he didn't remember whether he was devastated. He said that.
It's not true, folks. I have more Rolexes than ex-wives.
Pointed out on the transcript. He said no. He did listen to it again. He said, yeah. He said he was devastated.
I was just asked, can the defense object to this? Yes, but if the defense objects, it kind of looks like there's something to hide.
Devastated when you talked to Mr. McCullough?
They're not making their case very well here anyway.
Mr. McCullough did say.
Don't draw attention to their shit or to any point that they have while they overall are producing a shit argument.
That's what the testimony was.
Wait, this is a shit argument?
He gets up here and says, well, I was in shock. I was in shock. I was in shock. That's why I couldn't remember anything.
I wouldn't know. I can't understand a fucking thing she's talking about.
He was medically cleared twice that night.
That's not. You can get medically cleared and still be in shock and trauma from shooting someone who's trying to kill you.
Don't you think when dispatch asked him how he was, he would have said, he seems like he's in shock. I think you need to get an ambulance.
This is speculation.
And don't you think if he was really
speculation,
or he was hurt to the point that he had been sprayed with something and he had been injured somehow, don't you think
instead of ignoring the question of
Locals has found a picture of the prosecutor without her
answered?
mask on. Just a second, I'm about to
Unless
post
you
it.
want to believe that
Oh
Officer
no,
Crispin was lying
it's
about
gonna be
that.
an elephant.
So far, Crispin's lying for no apparent reason.
You people are terrible.
Don't do that to Gary Busey.
What the ever did he?
Credibility.
Gary Busey would be making a better closing.
Red herrings.
Now you see what he did
Because-
was he got up on the bunk and he started firing.
Contrary.
It's
to
all in love.
what
L means
Fucking
long.
things like- Believe me.
Damn.
Everything that they talked about, for the most part,
For the most part.
is a red herring. And you know why?
No, tell me.
Because they don't want you to look at what was found at the scene, what wasn't found at the scene, and they don't want you to use your common sense. Because if you use your common sense, I mean,
They literally talked about what was and wasn't found at the
make
scene.
no mistake, ladies and gentlemen,
Like they actually
the
did.
only reason that this alleged encounter with Drunk Guillermo on a horse, which came up for the first time when he testified here, why is that relevant? You know what it's for? To make the victim look like a bad guy, a drunk, a fallen over drunk. That wasn't even at the time of the incident. Why was that relevant? Why did they bring that out?
Lots
It's
of
a red
testimony
herring.
about his habitual drinking.
Fatty liver. He had fatty liver. He must have been an alcoholic. No, Dr. Gerald said it could be from
It could be.
obesity, not just alcoholism.
He wasn't obese.
And she said alcohol use, not abuse.
Oh, jeez.
I don't know why I'd remind the jury of this
So
testimony.
it's great that the neighbors in this neighborhood frackle or whatever happened there.
Frick
They
fracka?
can get up there and tell you what happened.
What's a frick fracka?
Durka.
Neighborhood disputes especially, there's always two sides. Unfortunately, Guillermo can't come and tell you why he's great.
That's such a cheap line in every one of these cases. Only one party can testify. Yeah, because they tried to attack someone, got shot.
And he sure as heck didn't go get a weapon to shoot his neighbors with or to defend himself with.
Did his neighbors attack him?
He attacked their dog with mace.
Oh, wait, you're talking about Guillermo. Oh, okay.
Yeah.
Yeah.
And if you were paying
It's always
attention and they
The
know you
closings
were,
where they have the least to say that go longest.
This is
It's supposed to be a
just
rebuttal.
sad.
It shouldn't be longer than the defense close.
times
If we cut out the dead
When I
air,
would
it'd only be
ask
about
him-
6 minutes long.
about things that don't make the story make sense. Like the time, why didn't you follow?
Did you call the state of Wisconsin, though?
Why did you say it was poison and not a neurological gas? You never said that, so I don't understand. Why did you, for 2 hours, refuse to give your correct DOB? Well, I didn't do that. Why did I do that?
This is just
And really, the 2 different magazines. He said he had a lot of magazines there.
I don't remember that testimony.
There. What is the big deal about 2 magazines? We know he admitted. He even put the weapon there for them to see.
Then why'd you bring in the
only
other
that matters is the
magazine?
one that was in that gun. And the only 2 rounds that matters are the 2 that hit Guillermo.
No, that's not true. All the other ones matter too.
Yes. And that's what he doesn't have an explanation for. He doesn't have an explanation of all
He
the
doesn't
time
have to
that
explain
he lied.
anything. There's no
Yeah.
burden on him.
So then he said, well, I
It's
can't
burden shifting.
remember. I can't remember
this
the
is
time.
this is
I've
just
been wrong.
closing arguments by William Faulkner's stream
Yes,
of
it is.
consciousness
Pattern
speaking
done.
here.
That's it. Talk about speculation.
Said with even worse dialogue.
That could have been him washing the blood off.
James Joyce. It's the James Joyce closing argument.
It starts somewhere in the middle and it ends somewhere before that.
You see the amount of blood that was there.
Ladies and gentlemen, the jury, it's like, why do I keep getting ghosted? It doesn't make any sense.
There would have been blood on here. And the reason we asked you to look so carefully at the canister is because it's clear. You don't need an expert to tell you. Look at it. Look at the picture.
Doesn't this just sound like the ramblings of just someone that's hallucinating? She's just talking to random people.
Are there finger grooves on the canister?
Most of them, yeah. I mean, this is not the same one. It's very similar. It has little finger grooves on it. The OC spray I carry now doesn't have a finger groove, I don't think.
Whether he was sprayed or not.
A little tiny.
If you stuck with it, you don't glance and blow. Maybe you sprayed on his face and that stunk for a while. The mace wasn't sprayed. And there is no explanation for why. If it was happening like Guillermo, like the defendant says, and Guillermo striking him over and over and over again, why, if you wanted to attack him, wouldn't you turn the mace around and use the mace?
This is all speculative.
Wouldn't that be a lot more effective than just trying to hit him with this?
Why wouldn't it have?
People always do stuff that's less effective than what they could do. Especially drunk people who have cocaine in their system.
Seriously. And if
John Wick wouldn't have done it this way.
Where he said it did, when he was first pushed down, he's the one who grabbed that weapon. He's the one that introduced deadly force into this altercation. Not Guillermo. Mace is not a deadly weapon under any interpretation of the definition that you've been given.
No, that's not true.
I would object to that.
I would object.
Cause death, great bodily harm, permanent or prolonged impairment of an organ.
Yeah, I would actually very much object to this. She's
Impairs
making a
lungs,
statement of
impairs
law.
vision. Yep.
And I suspect that's why after he realized that, oh man, I put that can backwards. I got to come up with a reason for that. So I suspect that's why the story came up with.
You suspect that's why?
Yes. Doesn't make any sense. It's not reasonable.
It's the Chewbacca defense.
And I say briefly, and I'm not going to dwell on it, but
It's like he didn't tie his shoes properly that morning. Is that reasonable?
it's easy for jurors to get distracted by things that don't matter.
Because you're not very bright, let's face it.
It's tension you might have seen between counsel. It happens in trial. Don't let that impact your decision. Either way, it happens. I have tremendous respect for these two ladies. They did a hell of a job defending him. But common sense does not go away. Look at how many instructions tell you to look at reasonableness or common sense. The ejection patterns, what would that have told you? There's no alleged encounter with the horse, the fatty liver. Oh, even some more red herrings
Did she
today.
go full Biden?
Yeah.
They want to attack Mr. Walker, jumping.
She did.
I think those pre-closing shots are starting to kick in.
Doesn't even know when the sun
Talk about fatty liver.
Shooting reconstruction.
That's the name of her cat.
Fatty liver.
But here's the real thing, though.
You should just start talking backwards.
To
It'd make more
believe
sense.
Fire walk with me.
that a struggle happened in that little house.
I believe
where
I'm
Mr. Adiola,
struggling to give a shit about what you have to say.
I'm struggling to understand.
wants you to believe that he's drunk all the time, and he's high on coke all the time, and yet he never exhibited this behavior before to them.
This reminds me when I.
She's had enough.
She's like, bro, this is going on way too long. This is not a rebuttal. It's also stupid.
This reminds me when I first got separated from my ex-wife, she used to call me and just to have arguments. And I would literally put the phone down while she was yelling and go make a sandwich and come back with the sandwich and start eating it. And she'd still be yelling on the phone. Hope the judge says wrap it up.
All right.
All right.
Yeah, he did.
Yep, he did. Apparently, I'm out of time. Get wrecked, you dummy.
Oh my God, that's all she had to say? Apparently, I'm out of time? Oh, he's going to give her a couple more.
Oh, God. I thought she was just going to wander off.
She is. She's just wandering around.
Oh, my God. What the fuck?
She's putting her props away.
She's going to shoot herself. Oh, thank God we're not on YouTube.
You can't use deadly force to repel non-deadly force.
Yes, you can.
And there's no way any reasonable person would react.
You don't even have to have the can. If you're swinging at someone's head, it can be deadly force.
If you're fighting for the rifle, it's a gunfight.
I ask you to go back and deliberate with your fellow jurors.
Deliberate.
And I know you were paying attention and know you took notes.
Stop talking.
Compare your notes.
And ask yourselves,
She looks really confused.
did he act like a person?
I would stand up,
Whether
judge.
testimony, action afterwards, what have you?
I would object.
What have you?
Self-defense?
You should convict them based on what have you.
Or did he act like someone that knew he had killed someone without sufficient provocation and without
I would
being faced with deadly force? Thank you.
Jeez.
The judge is like, okay.
And someone asked, does the defense get a response to this? No. Prosecution ends the case. I actually hate that, personally.
The judge is going to buy his own wife, a Louis Vuitton bag on the way home. I love you, baby.
Thank you for not being that.
Yeah.
The jury. All right. Your entire courtroom will be a courtroom for your deliberation. What I'm going to do, let me read this instruction, and then I'm going to tell you the procedure that we need to follow to do that, okay?
Turn on your fucking mic.
I will not ask you to retire between deliberation. You will be provided a copy of the jury instructions as exhibits, introduces evidence will be made available to you. Prior to beginning
They're
your
watching the stream,
deliberations,
thank God.
you will need to select one of you to act as foreperson. That person will preside over your deliberation and will speak for the jury here in court. Forms of verdict have been prepared for your use, and they read as follows.
I'll be right back.
Find the defendant, Dean Cummings, not guilty of second-degree murder as charged in count 1 of the grand jury indictment. We find the defendant, Dean Cummings, guilty of second-degree murder as charged in count 1 of the grand jury indictment. We find the defendant, Dean Cummings, not guilty of voluntary manslaughter as charged in count 1 of the grand jury indictment. We find the defendant, Dean Cummings, guilty of voluntary manslaughter.
He's emphasizing guilty for each one of those.
Jury indictment.
No, he's alternating.
But I mean, he says not guilty. He says guilty.
With you into the jury room. The jury room will be this whole courtroom. When you have reached a unanimous agreement as to your verdict, the foreperson will sign the forms which express your verdict. You will then return all forms of verdict, these instructions, and any other exhibits to the courtroom. What I'm going to do, I have good news and bad news for two of you. The good news for two of you is you get to go home right away. Well, not right away. I need to explain something to the two of you. The bad news is you've been here 6 days or so, and you don't get to decide the case. The two
That's fine.
That are
Don't spend that $35 all in one place.
and Charles Law. And you are the alternate jurors. And
Did he just name them?
So is
I think he did.
I'm gonna have everyone. I'm gonna tell.
Come on, Your Honor.
Go take about an hour break and come
Holy
back.
shit. I think
When
you did.
all 14 of you are here, I'm going to release the 2 alternates. The reason I'm not going to let you go right away is that if something happens to either someone else, then I need 12 people to deliver it. So instead of holding you here while we clear this courtroom and the like, I'm going to have you go ahead and take an hour break. Come back in an hour. Once the 12 of you are present, I'll release the 2 alternates, and then I'll ask you to start your deliberations. All right. So go ahead and be back about 1:15, and then we will take a break. It's already 12, around 1:15, and we will recess early this afternoon for those people who need to go vote. Any questions before we break?
Can we just sign the papers now?
All right.
All right.
All right. Okay.
Wow. I just love how you just think it can't get any worse, and then it does every single time.
And with all this nonsense, folks, the chance of conviction is more than 0. Still a 10% chance this guy gets convicted, even though the state had garbage. Which is why we need better protections for defendants pre-trial, a real probable cause standard to drag someone into trial, and better protections for defendants after trial when these things are shown to be the charades they are, holding prosecutors responsible for these sham prosecutions. Good Lord.
Hi, Nick. Welcome back.
We'll be in
Hey, what did I miss?
Him naming 2 of the alternate jurors, we think.
Yeah, he named the 2 alternates, named them aloud in court.
What's that?
I was asking Andrea if she has my cell phone.
I'm not.
Yeah, just give it to the number in front of you.
We'll just give it to you again.
I don't have Donna.
And then we need to go get a
You have to. You can't do it. Oh.
What is even happening in the courtroom right now?
They're on a break. They're on a break for an hour.
But they got all the fucking mics on.
Yeah.
No audio. Okay, you can just take your camera off.
Okay, I'll just take it off. Can I set it on the floor? There is no audio. I'll unplug it.
Yeah, sit on the floor.
Okay, take it.
Okay. Yeah, we can't use our jury room now.
I understand it.
I can't believe the judge named the 2 alternate jurors there, though.
It's a weird flex. You think you can be jurors in my courtroom? I'll fucking name you. Chief Chris says, help make legal prices publicly available. Just visit gavelbook.com. We need traction to keep building. If you like it, tell your friends. You never know who might be looking to hire a lawyer. Well, have you ever heard of this? I've never heard of them.
No, what is that?
It sounds like some sort of website that tracks prices of legal services, maybe, and tries to aggregate them into something. I've never heard of them. Hey, Gavel Book, if you wanna actually like talk about what your product does sometime, let me know. All the time I get people asking me for like how much something costs, and it's like, well, I don't know, however much someone grease out of you. I'm gonna be honest, for criminal defense stuff, the same defense with the same lawyer will cost different things based on how much money you have in your bank account.
I've seen lost during a break.
So let's talk about that. Gnome John, this closing feels like it's gone on for hours. The prosecutions is pretty bad. Red
Hey,
Gen
he could
26.
be guilty. He could be guilty. Just use your common sense and watch out for those red herrings. I mean, he could be guilty.
I mean, maybe. You never know. Red Gen 26. Vote no on Michigan Prop 3 to protect our kids, please. Please. Yeah, Michigan Prop 3 is garbage, actually. Horrible law for Michigan. And it has some real risks involved in basically bringing a path to giving a constitutional right to minors to have transition medicines and surgeries. A constitutional right for a minor would mean no parents, no doctors could say no.
Can we leave these in the courtroom? Yeah, but I mean.
What are they doing with the camera? What is happening?
Oh, the entire courtroom is the jury deliberation room. Apparently, they don't have a jury deliberation room here. They're just emptying the courtroom, and they're going to deliberate in the courtroom.
It looks like there's the stream is down, so we'll remove that.
Well, as much as I'd like to sit here, it's 4:30 a.m. I need to get at least 4 hours sleep. I'm sure they're not going to come back with a verdict in 10 minutes.
I have no idea, man.
Oh, Lord.
A rational jury, but that's the problem. You never know what you have.
Yeah. Wow. Yeah, it could be 10 minutes. It probably should be 10 minutes.
Yeah.
But absolutely. Jeff, where can people find you?
Legal Vices.
Where?
On YouTube, and I think Rumble is my backup site, but I haven't streamed anything live there.
Sounds good. Guys, check out Legal Vices if you're still on YouTube. Legal Vices is an American lawyer who took the train to Busan and never came back.
34 years ago.
But he's a very good dude who I've been getting to know ever since the Depp trial. I really like hanging out with him. And dude, I'm gonna send you a link. I'm gonna do the election stream tonight. I'll send you a link if you want to pop in at all. And if you're like, I don't care about American elections, guess what? Neither do I, but we're going to be making jokes and having fun because that's the way to do it. So
I'll get to sleep and see how long I can probably get 3-4 hours sleep and wake up, and we'll see what happens.
That's how it
goes.
Nick,
Andrew, it's a pleasure as always.
Take care, Jeff.
Buddy. All right. See you soon.
Peace. It's down to just us.
As so often happens. Nick,
seems to be how it goes from time to time.
For two people who've never actually met, we spend a lot of time together.
Yeah, it's kind of gay, but I like it. I'm okay with it. So, anyways, guys, we've got let's see. We've got a couple super chats to read, and then we'll, I don't know, hang around and wait to see what happens with this thing. Hold on. But yeah, I'm gonna go ahead and hang around for a while. We'll see if the jury comes back. I can't imagine it's going to be that long. What do you think? Do you think this is going to be a long deliberation? If you had to just guess, obviously.
After that closing, I'd want to go home and have a couple drinks.
They're also they want to vote. It's voting day. You know, they could really want to get out of there. Guys, fucking awful. Ugh. I've still got the stream up. The stream is still going. I think when the jury's done, they'll probably just bring it back up on the same thing. So I'm trying to keep up with it. But all right. Okay, I'm gonna start reading these super chats, and we can talk about anything that comes up through here. Also, guys, a couple things real quick. A couple things. First of all, lawofselfdefense.com/Nick gets you an amazing deal. It gets you half off of a premium membership to Law of Self-Defense with Andrew Branca. I don't know if you guys know this, but this guy happens to be a little bit of an expert on self-defense law, probably like the expert on self-defense, use of force law in the United States.
I've heard that.
And
mostly from me, but from other lawyers too.
And he used to do consulting. Just, you know, someone has, oh shit, I had to act in self-defense. Not necessarily I had to shoot someone and kill them, but I had to act in self-defense in some way. I'm now facing criminal charges. I'm going to hire the expert. They would, you know, their lawyer would call Andrew up and say, hey, would you consult on this case? That's no longer available to the public. If I'm not mistaken, now the only way to do that is to be a platinum member for Law of Self-Defense. .com/Nick to get yourself half off that platinum membership, which is if you're ever in a self-defense situation, having an expert at your disposal is critical. And as we've seen with public defense cases where they don't really have adequate experts, you don't want to be in that boat. You don't want to be in that boat.
Often the experts are bad. Often the defense attorneys aren't quite up to snuff on this stuff. They're not used to defending good guy cases of self-defense. And even when the defense counsel is good, like in this trial, defense counsel was very good. There's still little things I would have done different. And it might make only a 5% difference, but do you want a 5% better chance of not spending the rest of your life in prison? That's the stakes we're talking about.
Exactly. And it's critical. There's one more thing that is critical as well.
I mean, if I honestly on this close, I would have been put a lot more emphasis on both the burden, which they touched on, and then they wandered away to talk about other stuff before they left the jury. The last thing I would have left the jury with is recounting what the burden is, how high it is, and who it's on. And I would have focused much more on what reasonableness means in this context. It's the reasonableness of these specific elements that matters. Not was it reasonable for him to sit in his truck, or reasonable for him to drink a soda, or reasonable for him to say his name to the police on 911 and not say it later. The reasonableness of that conduct is irrelevant to the legal defense here. And anybody's going to do things that could be arguably of questionable reasonableness if you consider every facet of everything they did over a multi-hour period. But it's only these elements of self-defense that are required to be reasonable for your acquittal.
Right. And the emphasis was in some strange places, but the ultimate question in self-defense is, at the time of the shooting,
right,
is the person in reasonable fear? And so, well, what did he do later? What they're trying to get to is some circumstantial evidence that can show what the person's state of mind might have been at the time of shooting. But that's getting way attenuated and speculative. And the prosecution, if they want to convict someone, they need to focus on what happened at the time of the shooting. If I'm a juror and a prosecutor is telling me a bunch of stuff that happened afterwards to try and prove what happened during, I'm suspicious as to why they don't have any facts around what happened during the shooting.
And they should have preemptively undercut this prosecution argument of the mace not being deadly force. They should have distinguished between defensive and offensive use of mace. The fact that this conflict, this aggression by the victim escalated. It wasn't just mace as a spray. It was mace as an impact weapon. Then it was a fight for a rifle. And by the time the shots were fired, it was a fight over a gun.
Exactly. And when you're in a fight, you need someone in your corner. Sometimes you're fighting over a gun. Sometimes you're fighting for your life. Other times you're fighting for your future against a deranged idiot for a president who has raised inflation to historic rates and who has driven the stock market through a fucking roller coaster of market volatility. And the people you need in your corner are Birch Gold, the Birch Gold Group, who is sponsoring this show. If you go to birchgold.com/knows, which is linked in the description of the video on Odyssey and on Rumble, you can get to this webpage right here. And if you click on this little green button, and when you click that button, Birch Gold will say, ooh, right back to you. And they will get you some information about how to get gold and silver in your IRA or 401k. Look, they're not here to sell you a bunch of gold. They will, like, of course, you call them up, be like, hey, what up, girl? I need some gold bars. They can do that for you. But what they'd really like to do is give you information about how to get a proper amount of physical assets like gold and silver into your IRA or 401k as a hedge against inflation, not as an investment, not as some shoot to the moon promises on massive gains or something like that that would take World War III to get to anyway. They're just here to hedge against all of the shit that's been happening pretty recently in the market. And if you if you're in the market, I know that you're sweating bullets one day and buying champagne the next. These guys just help kind of smooth that out if it's right for you. Again, birchgold.com/nose. Click on this green thing. You don't have to buy shit, but they will call you up or email you or whatever. Oftentimes, if you do it during the show, they'll email you or get back to you during the show. So you can trust that they're there to help out with that. And if you don't like their product, if you don't need it, if it's not the right match for you, don't buy any. It's very, very simple, but it might be. And if it is the right thing, it could save you a lot of money in the long term on your retirement accounts. So look, I can tell you about their A+ rating with the Better Business Bureau. I could tell you about their thousands and thousands of definitely not bot generated positive reviews on all of social media. Or I could just say that, hey, they offered to sponsor this show. They know exactly who I am. They said, we'll never tell you what to say or what not to say. We don't care. We are pro free speech. And by the way, they went through a month of me telling shitty jokes, including some really banger Holocaust jokes and stuff during their ads. And they're like, yeah, we'll do another month. How can I argue with that? I can't. That's a company I trust. So give them a shot and see if it's right for you. All right. All right. My contractual obligation is complete. To Birch Gold. You're muted.
I just the other day I got an invitation to go speak at a high school. And I'm like, do they even know who I am? Who thought this through? Is this like a junior in the school or something sent me this invitation?
Let me give you a series of links.
A Catholic high school. A Catholic high school. I'm like, oh, I don't know. I don't think I should go.
Chief Chris is still here. He says, Nick, I'd love to talk about Gavel Book. I emailed you. My name is Chris Penza. Hey man, I got your email. I'll be responding to you. I really like the idea. Did you hear the Gavel Book thing at all?
He reached out to me too on I forget where, on Twitter. I'm not sure. It sounds like a great idea to me. I'm not sure it's a good fit for the kind of stuff I do, but I certainly think somebody should do what he's doing. Certainly the need he's targeting is something that definitely needs to be addressed for sure.
Yeah, there's just not like there is so much obscurity around the legal profession, and while it's got its uses and benefits, it also leads to a real possibility of exploitation for people who really need when you're in, it doesn't matter if you're in a civil or criminal case. Oftentimes your exposure to the legal system is the worst point in your life. And people are willing to do a whole bunch for that worst part in their life. And lawyers are willing to take a whole bunch of their stuff because of what they're willing to do. Some transparency can actually slow that down. And as an attorney who barely does any legal work, as little as fucking possible, having other attorneys get stiffed on fees that they'd be exploiting out of people brings a little happiness to my pants. So this profession has been full of dirtbags for way too long.
Yeah, there's a complete, utter lack of both transparency, and the consumer is completely ill-informed and unequipped to know what they're buying.
And the system makes it that way too. Like there's no way to inform and equip yourself. Like the only way to do so would be to contact attorneys' offices, ask them their hourly rates, ask them how much they tend to charge, which is going to be just a completely, they're going to say, but yeah, your situation will be completely unique, because it is.
And that only tells you the price half of the price value ratio, right? If you're looking at people, when I say people are ill-informed consumers, they can't evaluate the quality of what they're paying for. So right now you look at Nick, he's a lawyer. You look at me, I'm a lawyer. You look at Nat Lawyer Chick, also a lawyer. I would suggest we're not all the same lawyers.
That's right. And different lawyers have different experience, different practice areas, different demographic practice areas. A lawyer in rural Minnesota is going to have very different practice encounters than someone who works in, downtown Chicago. Even if they have the same like basic practice area, the the if you're a criminal lawyer in Chicago versus a criminal lawyer in rural Minnesota, we're dealing with different shit.
Yeah, different world.
So anyway, yeah, I'm really interested to check it out. And I'll definitely get back to you. Gavel book. Very, very cool. Very cool stuff. Next we've got, what is this? Matt P says, how much wine did she drink before getting up here? Sounds drunker than Nick at 4 a.m.
She did just start, like, words started tumbling out of her mouth like vomit.
Dude, that rebuttal was, I mean, the closing argument was bad from the state. The rebuttal was unintelligible nonsense. It was like someone just walking around, just meandering, like just lost in thought, non-thought, really. It was just.
And then finally the defense objected, and she has to come back and just summarily tell the jury, I guess I'm out of time. That was great.
And then proceeds to meander for like another, several minutes of just,
I mean, why would she say that? Why wouldn't she just come back and pretend like it was something innocuous just happened? She didn't get shut down by the judge completely.
Here's a tip. If you ever get a sidebar and the judge sustains the objection, just go back and say, as I was saying, but don't say what you can't say.
Right.
Just act like you won the encounter. Who cares? Just don't be undercut. Okay, here we go. Safori, Safe for One, 1790. Speaking of voting, I got up and voted 30 minutes after polls open. Live in Pennsylvania and walked to my polling place with the previous day's leg injury. There's no excuses to not go and vote, especially with how this election seems more important than most. Let me just mildly say that every election I have ever seen in my entire life has always been billed as the most important election of all time.
Yeah, I voted for Reagan, folks. I voted for Reagan. It was the same arguments by the Democrats, by the way. All the Republicans were Nazis, going to throw grandma off a cliff, going to end Social Security. It's the same arguments. They make same scare tactics my entire adult life.
I do got to say this, though. I got to say this about the Republicans in Minnesota. You know what? I hope you guys win, mainly because I just don't want more taxes. I have no faith in you to lower my taxes, you feckless cunts. But I hope you win. But you dumb motherfuckers accidentally legalized Delta 9 edibles in Minnesota, which was the accident was the best thing that you've done in years and the funniest. But then you made Delta 8 illegal. Why? Oh, why are you still like this? Like, why are you still like this? I don't even like it. Why do you keep perpetrating upon your populace this insane ban on marijuana? Like, no one, it's the most unpopular thing to keep it illegal I've ever heard. And the Republicans are like, oh, we're going to wade right into this wave. We're going to just walk and just let that fucking tsunami hit us right in the face. Guys, like, focus on anything else on the planet. Delta 8 is not killing anybody. There's no rash of like murders and kidnappings over Delta 8. It's just a bunch of weirdos vaping in a restaurant. Get the fuck over it. Sorry. I got this little rant because I just hate them, Andrew. I hate them. They can do anything. I don't know what
Delta 8 and Delta 9 are.
Okay, so Delta 9 is the traditional THC strain that is in marijuana, right?
Okay.
It's the psychoactive substance in marijuana.
All right, so you're talking what, edibles here or something?
No, all
just weed.
Like any weed,
okay.
weed edibles, weed resin. The Delta 9 THC is the chemical component of it that makes you high.
All right.
That is the control. That's the Schedule 1 controlled substance.
Okay.
There are different strains of THC, like Delta 8, Delta 10, Delta 11. These are just slight variations, and they don't have the same potency or effect. But since the Schedule 1 is on Delta 9 THC, any of the others were legal. And so they started actually just producing this other strain of THC, and people get various effects from it, similar stuff like anti-nausea, anti-anxiety, stuff like that. So people are just enjoying this from, you know, smoke shops typically. And now they're like, whoa, we got to make that illegal too. Holy shit. We can't have people just not being controlled. Will you guys just fuck off? Like, just fuck off for a little bit. Anyway.
Well, you come to Colorado, we have all the weed you could possibly want everywhere.
I don't even want it. I don't even want weed. I don't care. I have like this, I have these gummies as a meme for some of my local streams. That's it. Just because the Republicans oh yeah. So the Republicans in Minnesota accidentally legalized Delta 9 edibles only. They didn't know they were doing it because so there's the Industrial Hemp Act in 2015, which allowed hemp to be produced so long as it has less than, I think, a 0.3% concentration of THC in it. And so that's what allowed like the big boom in like CBD oils that you see everywhere, CBD infused fucking everything. So once that happened, Minnesota made it so you could have this industrial hemp, you know, oils and lotions and stuff like that. What the Democrats did in Minnesota, which was actually really fucking funny, is they put an amendment on a bill to regulate edibles as long as the edibles came from the industrial hemp. So as long as the THC was derived from that. But the thing is, if you have 5 milligrams of THC, it doesn't matter what plant you got it from. You still have 5 milligrams of THC. You just need more of the industrial hemp to produce the same amount. And so they effectively legalized gummies. But the Republicans were too dumb to read the fucking bill and figure out that that's what was happening. So they're like, "What? Did we just legalize weed?" And the Democrats are like, "No, you didn't. Don't worry about it." And turns out they had, which was great. That made me really happy.
Oh, politicians! It's not like we ever send our best and brightest. Let's face it.
No,
if they were capable, they'd be out making money.
They
instead of stealing
it. They just spent 5 seconds reading the bill and would have seen it, but they didn't. Anyway, I have to make fun of them eternally for that. Okay, here we go. What's next? We got Lagging says, how much of this trial is because he used an AR and AR is the current boogeyman?
Definitely part of it, I think. Yeah. I think part of it is the ethnicity difference. The victim is Hispanic. The shooter is white. Part of it is a community in nature. The victim is a longstanding member of the community, lived there all his life. The victim's a newcomer to the community thinking about moving in. The AR rifle was definitely part of it. Sometimes it's weird. Sometimes little initial perceptions by the police officers can make a big difference. I was consulted on a murder case with a young woman as a defendant, killed the guy in a one-night stand. And near as I could tell, the only reason she was prosecuted was because when the police responded to the scene, the dude was dead. I mean, she managed to puncture him in the aorta with a little folding knife. He was dead, and she didn't know he was dead at the time, by the way. She thought, is he going to be okay? She's asking the officers. And the police wrote in their reports they found her demeanor oddly calm. And that was the only thing inconsistent with a narrative of self-defense. And they prosecuted her for murder. And we were lucky to get those charges dismissed 2 weeks before trial.
Jeez.
She was 20-something, 22. She would have spent the rest of her life in prison.
That's such a fun way to go.
And only because the cop, their initial perception was, well, she seems a little calm for someone who just stabbed the dude in the chest. That was it. But it was in all their reports. Every officer wrote it in their report.
The crazy thing about that is there is no standard trauma response. Doesn't exist.
Yeah, and with this defendant in particular, this young woman, she'd thought about this possibility before. That knife had been provided to her by her father to defend herself. He'd gotten her training in how to use a knife in self-defense. So she thought before, someday in my life, I may be attacked and have to stab somebody in self-defense. So when it happened, it wasn't the kind of total shock as someone who'd never before contemplated that they might have to use deadly force in self-defense. It wasn't like, I can't believe this is happening. It's like, oh crap, I thought this might happen someday.
Yeah. And but even so, like, even if that's your prep, you never know how you're going to act under stress and trauma. which is why the standard advice after a shooting is to get a lawyer to do as much talking, or, you know, any self-defense encounter, have a lawyer do as much talking for you as possible. One, they're trained, and two, they're disinterested, and three, they're not traumatized. And that trauma is, you don't know what it'll be like. In the same way that, like, we don't know how police will react to being shot at or anybody, because until it's happened, you just can't. But anyway. Oh, someone's asking me what state that happened in.
The case I'm talking about, California.
California.
Is that lawyer chick going to complain now because I'm not barred in California?
Oh yeah. Yeah. Well, now you're disbarred everywhere now after admitting that.
I guess
the Coltrane says if this is the prosecution against Baldwin, he's going to walk.
Yeah, I mean, an argument can be made if you're going to commit a violent felony, do it in New Mexico, because the prosecutors suck.
In Maricopa County, right? Like, is that where this is? Or wait, is that Arizona?
That's Arizona. That's where they're stealing elections. That's a different crime.
Yeah. We'll see if they get away with it this year. Let's see. Bald Eagle, 1787. Branca. Nick, it looks like this case is yet another attempt to reduce, if not eliminate, any right to self-defense. Also heard that the DA pulled a Binger and brought in something the judge said not to.
Well, there were several points that are reversible error. I mean, just like in the Rittenhouse case, the prosecution here made a reference to the defendant's Fifth Amendment right, saying we didn't, in front of the jury, saying, well, you know, we didn't have a chance to interview the defendant. Of course, you didn't have a chance to interview the defendant. The state doesn't get to interview the defendant,
right?
And that was at least one thing. Then they said in front of they started to reference in front of the jury that he'd been held in jail for 2.5 years prior to the trial, which is another big no. They tried to reference in front of the jury that he hadn't seen his adult children in some number of years because he had a bad failed marriage and there was a protection order against him. I mean,
that's prejudicial.
Yeah, the defense objected and withheld it, but those are all things the state tried to bring to the jury's attention.
And so those are some of the appeal points, I'm guessing, right?
Right.
That you mentioned earlier.
Certainly the Fifth Amendment issue, because that was a full made statement in front of the jury.
Yeah, yeah, and we saw that pop up in the Rittenhouse case as well, where the state implicates in front of the jury the defendant's right to remain silent, and Schrader lit up Binger for doing that, but then he kind of let him off the hook. But I mean, that's mistrial material right there. You cannot do that. It's a big no-no from the state. Every prosecutor knows it. It's drilled into them over and over and over. You cannot implicate their Fifth Amendment right to defend to remain silent. You just
and the defense asked for a mistrial, which of course was denied. They're always denied, it seems like, but it is preserved for appeal. I mean, it's sometimes it's a difficult call. I mean, the prosecution here is really so inept. You couldn't ask for a worse case against your client. It's terrible because you might still get convicted. But they really have a shit case, and you're almost afraid, oh my God, if I get a mistrial here, I mean, it would have to be a mistrial with prejudice against the state so they can't just retry him again. If he's just going to be retried, you might end up with competent counsel on the other side of the table, and that would suck. Yep,
you definitely mistrials got it. Yeah, that was one of, again, a big thing in the Rittenhouse case when they asked for a mistrial without prejudice. It was really weird. It was a weird spot to do that. Maddie G88 says this case is ridiculous. It should have been dismissed. Well, it doesn't seem like they have probable cause. Like it just doesn't seem like they've got the case for it.
Well, so, I mean, we don't have a real probable cause standard in America. I talked about this in the context of that Patrick Leolia case out in wherever the hell it is. That's another case where the guy, the suspect, of course, it's a white cop and a black suspect, which is why it's in the headlines. And the black suspect got control of the cop's taser, and the cop shot him in the back of the head during the fight. Now the cop he had a probable cause hearing in front of the trial judge, and trial judge said, nope, probable cause. We're going to trial. And there is no probable cause by any reasonable definition of probable cause. I mean, it's in the words itself, probable. It should at least be more likely than not that you committed the crime in order to drag you into trial. But that's not how it works. How it works is, you know, if a leaf off a tree goes drifting across the judge's desk and he signs it, there's probable cause. If the prosecution has any narrative where if you only listen to their side of the facts, it could 1% chance be a guilty verdict, even in front of an irrational jury, that's probable cause. We have no probable cause threshold in this country, and it's absolutely terrible. If the prosecutor wants you to go to trial, you're fucking going to trial. That's just the way it is. And that's wrong because the process of the trial, just look at this guy. There was no probable cause standard when he got indicted by a grand jury based on testimony of a detective who didn't do any of the forensics tests or studies or even request them that he said would support his expectation of murder. It's utter nonsense. And this guy, even if he's acquitted now, he spent 2.5 years in jail.
And he won't get to recover anything from that.
No, nothing. And he's not been working, right? I mean, just imagine if you couldn't work for 2.5 years. Well, just what would happen to your life? What happens to your home? How does your mortgage get paid? How do your car loans get paid? How does anything happen?
Yeah, you have to have someone else who can take it over and manage it, or else you're going to lose it. I mean, that's the end.
All your mortgage company cares about is you didn't pay your mortgage for 2.5 years.
Your credit will be ruined. That'll be nice. All your stuff's going to sit there. Even if you get it paid for, like just leaving a house and stuff for 2.5 years, you're going to come back. It's going to be a mess. The stuff in your fridge didn't get cleaned out, has been growing. Like, unless someone went and cleaned up your stuff, it's fucking gross. Sub-Zero Beef, thanks for covering this trial. I'm from Valdez, Alaska, where Dean is from.
Yep.
And have met and talked with him many times. There's a huge news in our small town. Keep up the great work. Awesome. Very cool. Vinny D95. So is her theory that if I'm trapped in a small room and I defend myself, it doesn't count because it's a small room?
Pretty much.
It kind of seemed like that, which is interesting because it being a small room, one of the kind of, now there's no duty to retreat in New Mexico inside a home. Or is there full stand your ground?
So it's what I would call so like 39 states are stand your ground states. There's no legal duty to retreat. Most of those, I think all but 6 or 7 are what I call soft stand your ground states. So there's no legal duty to retreat. But the prosecution is still free to argue that if you could have retreated, a reasonable person would have retreated, and therefore your failure to retreat is unreasonable. And you can fail that element of reasonableness, one of the 5 elements of self-defense. It's not a legal duty, but the jury is allowed to consider it in the context of whether or not it was the conduct, your failure to retreat was the conduct of a reasonable person. There's about a half dozen or 8 states I call hard stand your ground states, and there the jury's instructed they're not even allowed to consider the possibility of retreat in evaluating reasonableness. Those are hard stand your ground states. Retreats really off the table. But what the prosecution was arguing here is, the jury was just instructed you can stand your ground. There's no legal duty to retreat in New Mexico, but they were still permitted to argue, hey, he could have gone out that door, and a reasonable person would have. That's the classic soft stand your ground argument that the prosecution makes.
Yeah, and I don't like that. I think if you're going to have a stand your ground statute, then eliminate the duty to retreat or even the opportunity to retreat if that's really what you're going to do. Right.
It's a backdoor way of attacking your failure to retreat when you can't attack it directly because of the stand your ground law.
Yeah.
But it shouldn't apply here anyway. And frankly, the defense should have addressed this too, because even if it were Massachusetts, which is a hard, you must retreat if safely possible state, it still only applies if it's safely possible. You don't have a legal duty to do something that's impossible or something that increases your jeopardy. And here he was under active attack. There wasn't some pause in the middle of the fight where he could have made a decision to walk out the door. That's not what happened here.
And one thing I wanted to say about that as well, that I was about to just gloss over, but once you talked again, it let me think, which was nice. Thank you. Is that the way the standard is articulated for when your duty to retreat is fully absent in Minnesota is when your quote unquote back is against a wall. I guess I didn't talk about this on here, but I think it was on Facebook during the Zimmerman case, because his back was effectively against the wall. The wall just happened to be horizontal and was called the ground.
Right.
He could not retreat at the time that the use of force was employed. And the same thing here. If you're in a small room, I think she said like 7 feet by 7 feet. Like it's a freaking closet.
Maybe 7 by 9. It was very, very, very small.
Right. Like this is a small room. And you see where the bullet casings and stuff are. He's literally back against the wall. There's nowhere else to go.
There's 2 bunk beds. I mean, there's a bunk bed on one side and there's just a bunk on the other side. So much of the space in the room is actually consumed by the beds.
Right. So like you're saying, even if there's a reasonableness factor that says, okay, reasonably you would retreat in this situation, that ends when there's nowhere to go. It has to, because you cannot be forced into a death compact just because of where you end up. Okay, Taryn M 0826. New Mexico's a total shit show. We didn't get to 51st in education for nothing. Praying for Ron Chetty to win governor today. Well, good luck. And a big shout out to everybody who is able to get out and vote and to make your political will be heard in whatever limited capacity it may be. It is a pretty important thing if you actually care about elections. And when people hear me say that, they go, wait, does Nick not vote? No, I do. I do go vote. And I vote in all of the elections that I have any interest in. I skip some of the, weird like water district stuff because everybody in my town is named like Chip or Skip or something like that. Everybody goes by a freaking nickname because they've all lived here for 90 years. And geez, I don't, it doesn't matter to me. But I vote on all of the stuff that that matters. I'm kind of thinking I should have run for attorney general this year, but just for the memes. You're muted again. You keep muting.
500,000 YouTube followers probably make you attorney general.
Nyotsu says, Nick, I need you to review the shoulders of my future governor of New Mexico, Mr. Ron Chetty. Okay. Who is he? Ron Chetty. Ark Ron Chetty. We're going to do a shoulder review of this guy. Images.
By the way, Steve Gosney emailed me. He said it is the hurricane in Florida that's effing up his attempts to get home.
Oh, gotcha. Yeah. Well, hopefully his home will be okay though. This dude is pretty broad. Here we go. Let's get him pulled up here. This is a wide boy, Ron Chetty.
Oh yeah, look at that neck.
Like, we're gonna rebuild the state of New Mexico. I bet you could. I believe you, sir. Are you a
Lift
carpenter?
it up and tilt it and shake all the progressives out of it. Shake them all back into California. I'd tell you though, Taos, New Mexico is one of my favorite places to go to on my motorcycle from where I live in Denver. And I like it. It's pretty, but last few times I went there, especially during the height of COVID, even after Colorado had dropped its mask requirements, man, there were signs everywhere. Wear your mask everywhere. If you tried to kind of half-ass it in a restaurant, they were all over you. It was, it's that kind of place.
I hate the mask stuff. I just hate it. I get so tired of it so fast. What's this? Kyle Bogue says, since it's election day, I just wanted to say, fuck Tim Walz and fuck Keith Ellison, turn Minnesota red. I agree. And then if they would just lower taxes, we have the tax rates of California. Why? Oh. Dude, Chief Chris, how much do lawyers cost? Find out at gavelbook.com. New version released today. Crusader Saracen, Jeff, are you going into Cochran's closing arguments? Greatest closing argument ever, regardless of what you believe about OJ's guilt. Talking Trash and Truths says, such a wealthy group of handsome men and such a handsome group of wealthy men. Lol, you've got double the amount of people watching that Brand has. Impressive. Have fun. Beasts. Oh, Russell Brand. I want to talk to that guy.
He seems like he would be interesting.
Yeah. Let's see.
Certainly wouldn't be boring.
No. No. Bald Eagle 1787. Can the federal government create and pass law mandating that all states must recognize self-defense like Castle Doctrine or Stand Your Ground? No.
No. I mean, all states have Castle Doctrine. All states have self-defense. And it's pretty much the same across the 50 states, except for that Stand Your Ground issue. But it's already like 39 states are effectively Stand Your Ground states, either by statute or case law. There's only 11 states that are not. And mostly small states, and the number keeps diminishing. It only ever goes one way. In my entire career, I've never seen a state go from stand your ground to duty to retreat. It's always the other direction.
Yeah, because people eventually end up realizing that they don't want to get killed. And they want to have the best possibility to defend themselves.
Yeah. I mean, and the duty to retreat is bullshit. I mean, if you think about it, again, we have these 5 elements of self-defense, right? Innocence, imminence, proportionality, avoidance, which is the duty to retreat, and reasonableness. The stand your ground states just take avoidance out. You still have to meet all the other elements. You still have to be the innocent victim of an attack. You still have to be defending against an attack that's actually happening. You still have to use proportional force. Everything you do still has to be reasonable. All the stand your ground states are saying is if you have those 4 things, you're the innocent victim of a deadly force attack happening right now and you conduct yourself reasonably, we're not going to put you in a cage for the rest of your life. The duty to retreat states are saying, we want one more shot at you. We want to be able to argue to a jury that you could have safely retreated and didn't. F that.
Schmo 723. Ugh, I served jury duty in this courtroom for a month this past summer. Can you imagine having to go to jury duty for a month?
Grand jury, maybe?
Just fucking kill me. Matt, like the depth jury, 7 weeks.
Well, that's an uncommon case.
Yeah. But we cover a lot of uncommon cases
right.
when we stream. Daryl Brooks is a month long. God, or it was 3 weeks, I think. It was 3 weeks. It's still long. This case is actually a reasonable amount of time. It was what, 4 days, 5 days?
It was a week. It's kind of long for a murder trial, really. But if you look at it, I mean, the whole defense case in chief was 1 day. Most murder trials, folks, typical murder trials are a day or two. The ones we tend to cover tend to be longer because they're politically energized or racially energized, and there's a lot of circus around them. But a typical murder case, a normal run-of-the-mill murder case, it's a day or two.
I just want to watch Borowski trials all day. That's what I want to do. Guy's been the best judge so far by a mile.
And the only reason this one was long was because the state had no case. So they had to keep talking to make it seem like they had a case. That's why the state's case in chief was 4 days long or 3.5 days long, and the defense was only 1 day.
Matt himself says, next, I would have said the state talks more about the thin walls. They expect him to go through it like the Kool-Aid man to keep retreating. It was just it's such a weird thing. Well, these walls are thin. Shouldn't this have happened? Again, these are statements about doubt. These are not statements about defeating all doubt. Danconia Copper. Do prosecutors ever realize mid-trial they ruin an innocent man's life only to double down to evade the humiliation of admitting it? Or is that too often their only concern is a notch on their belt?
Once they're in it, they're in it. It's not My Cousin Vinny. that doesn't happen.
Yeah. There are occasions where prosecutors way later will, when presented with like basically almost irrefutable evidence, they will recommend to the state to nullify a conviction for various reasons. But yeah. Bald Eagle 1787. I feel the defense should have a rebuttal last. The state should never have the last word when it comes to possibly locking someone up for the rest of their lives. I agree. I really hate that the prosecution gets the last word, personally.
It's very powerful. They get the first word, they make the first opening statement, and they get the last word. And I've said it many times, but if you invite me to a debate and you let me speak first, I'm 90% of the way there to win in that debate because I get to define the battlefield, frame the terms of the fight. And then if you let me speak last also, holy crap, I'm sorry. That's going to be tough to beat. I don't even care what the issue is.
Yeah, it's just you get to set it up. They have to respond. They're forced into your narrative. And then you get to defeat whatever thing they may have come up with, or you get to, go back against it. I just think that it's not the correct move. But that's the system that we have.
And the only offsetting balance, of course, is that we do put this burden on the state to prove guilt beyond a reasonable doubt. So it's not a 50-50 preponderance of the evidence standard, but still, given the way we give prosecutors enormous power and discretion and authority. And that's, anytime you're giving someone a lot of power, it works out okay. Depending on the person you're giving the power to. If they're a reasonable person who respects the authority and the limits of the authority, it can work out okay. But if you give that same power and authority to some shitbag, you have chaos on your hands. And that's what we see with a lot of these prosecutions. These prosecutors have all the power and authority we would want to be in the hands of good prosecutors, but you can't count on them being good prosecutors.
Dharma says, it's nice to see the Pope, the Lorax, and Andrew Bulldog Branca together again. Great show. You could say Andrew's like a pit bull.
A pit bull? Don't shoot me, bro.
Just giving you shit.
I'm one of the loving ones, one of the well-trained loving ones that doesn't maim and kill women and children.
Carrie T, as a medical provider, I've been released from every jury call I've ever gone to, all criminal, by the way. Have you ever seen a medical provider kept on a jury?
I don't know what medical provider means. I've seen plenty of nurses on juries.
Yeah, I'm not sure. Maybe a doctor. It really is going to depend on the case. I mean, if it involves...
Doctors have kind of a built-in excuse, right? Because there's always patients they have to care for. You can't put off patient care, right?
Yeah, but it sounds like this person is being released not because of their choice, like not because of their schedule, but just the way it's worded. I got the idea that they didn't want them because they were a doctor, not because the person didn't want to serve.
We'd have to know more about them than just medical provider. There's
But
lots of types of people that lawyers don't want on the jury.
Yeah, but it really does depend on the case. I mean, if being a medical provider is completely irrelevant to the question, then, I mean, there's no reason they wouldn't keep them if they wanted to be on.
Yeah.
But
I mean, I've been sat on a jury. I was sat on a civil jury. Thank God they dismissed it the first morning, so I didn't actually have to sit through it. But yeah, they put me on, and I urged them not to. I said, I think this is a bad idea, but
I've never even been called.
Yeah, lucky you.
Lorgar Apologist says, this entire speech makes me think the state doesn't think they are guilty. They're trying to eke out a win in spite of the obvious fact that they think he is innocent. They don't believe their own words. You can hear it.
Yeah, I mean, you could speculate that, whoever the actual elected prosecutor is in this district, for whatever political reasons, decided this was a prosecution he wanted to see go forward, and then someone got the shit end of the stick. I mean, when this woman, the shorter of the two prosecutors, the one who did the first closing, not the rebuttal, she did the opening, and it was awful. I mean, it was horrifically bad. It was like she was reading from a piece of paper the entire time. It was completely, and they've had 2.5 years to prepare for this case, right? It was completely as if her heart wasn't in it at all. None of the passion for justice that you would expect a prosecutor to bring to a murder case. Prosecutors make their careers on murder cases. And so it means a lot to them. It's like the World Series for them. And she was like, it was like she was in traffic court.
In the, the second prosecutor, or the one who did the rebuttal or closing today, actually literally did read off of a piece of paper very poorly.
Yeah,
it's
she's just terrible.
Wait, if you wrote this all down, can't you just like read it? Like, do you have a comprehend? Maybe she does have a comprehension issue. I don't know, but it's like, you wrote this down. These are your words and thoughts that you're going to now come up and relay on rebuttal, and you can't do it. What's wrong with you? It's weird. Matheraman says, Miss Raviolia, send me naked pic. Hello, bitch lasagna.
Okay.
Open Bob. Oh, can I ask Branca for his professional opinion on this self-defense situation? Yeah.
Sure. Are you a platinum member?
Yes. For the purposes of this.
All right, let me see.
So you got,
yeah, I'd say it's good. You got the tool or drill distance plus the length of the sword. So take 3.5 feet off that. Close enough. And he still has to draw from the holster.
That's the
I said that's
20.
good.
That's the 21 foot, right?
Yep. Right.
The Tueler distance. Is that what you called it?
Tueler drill, they call it, or Tueler distance, right? I actually do call it the Tueler distance because the distance varies. Like if the aggressor's uphill, he could close more distance in the same amount of time. For example, there's lots of factors that would go into what's the relevant distance in particular circumstances. But the classic is flat ground, have to draw the pistol from the holster. Bad guy starting from a standing position has to accelerate. It's 21 feet in a second and a half.
There you go. Bobby Johnson. But Nick, you are running for attorney general. I saw your Twitter campaign account at Unbreaded for Change. They have a link to your campaign website as well. Do they? Okay. Let's take a little gander at that. Unbreaded for Change.
Oh, I didn't see that was a deep fake of my face on the thing. Sorry, folks.
Was it?
That's someone saying that in the comments.
I didn't see that either.
I don't think those work that well for my face. It's hard for me to see myself in those deep fakes. I appreciate the effort put into them. I think Nick's face works great. He's always immediately recognizable. But for me, I'm like, is that supposed to be me or somebody else?
Here we go. Let's take a peek at this thing.
But maybe it's just some weird thing about not being able to recognize your own face that way. I don't know.
So thanks for your support. We at unbreadedforchange.com are looking forward to an unbreaded election here in Minnesota. And they got a little video here.
Wow, 2,500 views.
Wait, Nick Rekieta is running for Attorney General?
Stay unbreaded. Vote Rekieta 2022.
That's pretty good.
What's this? Wait, what?
I'm ready to fight for you.
This fucking picture. This is fantastic. I haven't seen this. There we go. Legal scholar, dank content creator / unbreaded. Perfect. You can get unbreaded. Oh my God. Wow.
What is that?
This is the origin. Yeah, we'll do it. This is the origin of unbreaded. It's 49 seconds.
Okay.
So, you know, when you hear people say unbreaded in my chat, this is where it comes from.
Touchdown. Paper? Unbreaded.
Right. This is that lunatic, right? The college guy. Right, okay.
On paper? Unbreaded.
It's a PhD in philosophy right here.
Touchdown. On paper? Unbreaded. Touchdown. Paper? Unbreaded.
I don't think that water filter behind him is getting all the lead out.
Touchdown.
Oh, here it comes.
Paper? I never gave a shit. This was never to these. Touchdown. Paper? Unbreaded. Die.
My man.
Oh, man.
That's Matthew Harris, PhD from Duke University and UCLA, philosophy professor. Cheers to higher education.
Indeed.
And higher hiring standards.
Send those institutions your tuition. Well spent.
Bob E. Johnson. Oh, wait, yeah. I just read that one. Okay, we've got oh shit. Can it please? Thank you. Dusty Debt says, I received a juror letter 2 months after my best friend and roommate was sentenced to 35 years. It was a Me Too case. Fuck. Yeah. Yep. Loads of Honey says, reminder to boost the stream with LBC, refundable in the wallet tab. Jack Crow says, caw, caw, caw. And Limestone says, I've never given Nick a cent, never will. Yeah, that was
for shame. All this entertainment? Come on.
It was less than 0.01 Libri coin, which is like less than 1,000th of a penny. So thank you. That's oh wait, Danconia Copper says maybe one day when I'm off probation, you can review my January 6th sentencing hearing where I can show full context of my videos the prosecutor selectively edited to present a bogus narrative. Yeah, man, we can certainly talk about that. Absolutely. How long's your probation? And we got Gaffregan. Nick, could you look into the Texas case against Sergeant Daniel Perry for shooting a BLM protester armed with an AK? Was supposed to go to trial in September.
Is this the guy who was an Uber driver? Is that case?
I don't know. No, Sergeant Daniel Perry.
I think he was former military. That might have been his former rank.
Okay. I don't know. I remember hearing about that case. Didn't it get dismissed? Let me see. Daniel Perry.
Or maybe he was still in the Army and driving an Uber. Yeah, he's the Uber driver case, right? Somebody approached his car with an AK during a BLM riot. Whoops. Sorry, autoplay there.
Let's see. July 2020, driving Uber in his time off. District Attorney at Austin is radical with an agenda, blah, blah. I guess it's still going.
The article I pulled up at the bottom, like other articles you may be interested in, one of those things, it says, Austin Police Department desperate for officers.
Let's see. Yeah. I don't know.
Is that me talking?
What? You've got a different, you've got volume coming from somewhere else.
Right. Yeah. Sorry about that.
Yeah, it said the trial was reset to September 27th, but there's no news on it, which makes me think that it didn't happen. But I have no idea. It was in Austin, Texas. Yeah.
I mean, you're going to have an Austin jury, right? So did he shoot one of their team? That's going to be a hard defense, not on the legal merit, but just on the politics of it. This is going to be like the Derek Chauvin situation. You're actually going to get a fair trial when people are lying to get onto the jury about being to protest against you.
Is there anything? Most recent thing I see is July 22nd, and that's the one that said that he was going to trial in September. So there hasn't been anything. I mean, that would tell me that they haven't done it. But I don't have an easy way to check. Let's see. Danconian Copper, 3 years. Option to terminate early after January. Probation officer says unlikely due to media coverage. Oh, isn't that nice? Isn't it nice that your probation canceling early is dependent on the media coverage of your case that you didn't ask anyone for and you don't get to speak to since you're on probation? Get wrecked, scrub. Iceman 1014. Hey, Nick and Andrew, need some advice, not legal. Friend of mine is getting ready to go into law school. She is not very confident, a good speaker, and has an excuse for every shortcoming. Not sure what to say. Any advice on what I should say to her? Would love to hear y'all's thoughts. I personally don't think she's going to succeed well in her field. Okay, wait. Are you saying you said she is not very confident? There are ton of lawyers and people in law school who are not confident.
Well, that doesn't make it a good thing.
Right. No, I know. But a good speaker, does that mean she actually is a good speaker, or is that carrying the not a good speaker?
Yeah,
So
I'm confused by the description. She has an excuse for every shortcoming. Her own shortcomings, or is she, I can't tell if you're trying to say she's a good arguer or.
Okay, so
I would recommend most people don't go to law school. I would recommend most people should not go to law school. A lot of people coming out of law school, they get that credential. They may even pass the bar, but we run into them every day. They're not good lawyers. They're not. They don't think in the way that lawyers need to be able to think.
But here's the thing to say to her.
But I won't.
Here's the thing to say to her, though, is like, good luck, work hard, hope it works out well for you. It's not your job to keep her out of law school.
No.
And she may surprise you, her, everyone with how she adapts to it. The other thing is there are attorneys who aren't in court ever. Like there are research attorneys. There all sorts of people who make very, very important contributions to cases or to companies without ever having to litigate anything. And that's
I almost feel
fine.
like you need a bifurcated system like they have in the UK, you know, where there's lawyers who have technical, academic legal expertise that can do kind of back end stuff, and then lawyers who can actually, you know, argue in an unpleasant way with other lawyers in an open forum and not take things personally and be effective for their clients, because those are two very different personality types.
Yes. And it's critical to distinguish them. And right now, everybody goes through the same courses and the same training, but it's not really the best way to do it. Because
that's how they do it in the UK, I think, right? They have barristers and solicitors. I get it mixed up all the time, but one of them kind of gives you advice in the office, like maybe, I don't know, real estate transactions or business transactions. And the other is the one that argues in court on your behalf.
Right. And in the US, we combine everything. All of law school is to make one like mound of all lawyering into one thing. And that's not how anyone practices law. You can't. It's too big. So, well, that's the chats. I don't know. Do we sit around and wait for this jury to come back?
Well, I don't think I will, Nick, because I have a I got to get this in the mail, buddy. To you.
I got to go vote.
My mailing address, and I have to go get a haircut too this afternoon. So I'm going to run those couple of errands. Then I'll probably come back to my desk and just keep an eye on the news and see. But I should be, other than the haircut and the run to the UPS store, I should be mostly around. So just you know, we'll just keep in touch over email or whatever. And but I'm not going to start my own stream on it. So whenever you start up, just give me a heads up, and I'll be happy to hop on.
Yeah, we'll see if they come
or if
back.
There's nothing. Whenever you do if you're doing covering the election stuff tonight, just let me know about that.
Sounds good, man.
All right, brother.
Catch you later.
Catch you later. Indeed. Take care. Bye, everybody.
Yep. All right, guys. That's Andrew Branca, lawofselfdefense.com. Gosh, I feel like I am not in focus. It's driving me nuts. That's a little bit better. How long have I been fuzzy? Too long. Anyways, I'm gonna wrap up the stream, I guess. There's no reason to just sit here. And I should probably go vote and stuff as well. So what I'm gonna do is I'm gonna hang out in my locals chat as I can. Wait, come back from lunch to release alternate jurors. Well, jury started deliberating 15 minutes ago. Oh my God, this could be, a while then. So I'm going to go vote and stuff like that. I'll keep an eye on this. If I see that the jury is coming back for, the judgment or the verdict, then we'll fire up another stream. But in the meanwhile, I'm going to go get ready as best I can for the election stream tonight. So we'll thank you guys for hanging out here on the Rumble and Odyssey platforms. And make sure on your way out, you pound that plussy, hit the plus button on the bottom left of your screen on a browser. On the Apple devices, the plus button is down in the bottom left. On Android devices, it's actually above. The thumbs up is above the video. I don't know why. It just is. So make sure you check or do that on your way out. I'm going to play the outro, and I will see y'all tonight. If you want to know when I'm going to start up any stream, always rekietalaw.locals.com. I'll catch you soon. Have a good night, guys. Peace. Peace. Where's the fucking outro? There it is.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more of love rug. The spirits blow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter, as we hear Lost Planning tonight. From the wide shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the wide shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we